Good morning and welcome. Could you please state your name and any institution with which you are associated? Please turn your mic on.
Good morning to everyone present. I am Kimar Stewart. I am the political leader of the New National Party.
Thanks, Mr. Stewart. The procedure here this morning will be that you please go ahead and make your presentation and share with us anything you would wish on the two bills before us, after which members may have questions for you. Please go ahead.
Thank you very much. First, thank you for the opportunity to come here to present. I respect the fact that you are seeking the public's input on some very important pieces of legislation. My first set of comments will be on the citizenship aspect. The Chapter 2 of the Constitution of Barbados speaks to what is citizenship, or how you could become a citizen of Barbados. Specifically, this bill was marketed to be an assistance towards CARICOM and developing CARICOM nationals into, or facilitating CARICOM nationals into Barbados's domestic space. And that time stipulated in the Constitution would have been 7 years based on Section 3.2. However, when you look into the citizenship bill, which speaks to the regulations of it, Section 15 says that the minister specifically may make regulations related to the registration of anything required or authorized under this Act or Chapter 2 of the Constitution to be registered. So I am asking if the minister has the authority to make what we call soft amendments to the Constitution of Barbados strategically. I am also concerned about the fact that it used to say Parliament had the power to do such things, and it only says minister in majority. If you look at the language in this act, it merely speaks to that of the minister. So I am a little bit concerned that the powers of the minister is actually overruling what was already prescribed for in the Constitution of Barbados.
Mr. Stewart, I'm only interrupting you on a matter of clarification. When you say it used to say Parliament, what are you referring to?
In the Constitution of Barbados, where it speaks to citizenship, there's a side section which says power of Parliament. So traditionally, or traditional legislation will speak to the power that Parliament has in many instances. But for this Citizenship Act, I hardly see any reference to Parliament. I see many references to the minister. Right? And based off our system set up collective responsibility, even though you may have a substantive minister, it could end up to be that the Prime Minister end up overruling that minister based off the collective responsibility factor. So just concerned about possible abuses of power that may happen from that perspective. It also speaks at Part D. It says relating to the giving of any notice required or authorized to be given to any person by or under this act. So for example, if there is a set period, a respectable period, of which a minister could issue a notice or request, etc., the minister can then say, well, I give you a day, right? Which may not be good for doing business or so, but I don't think it should be left at the discretion of the minister to specifically speak to, the amount of time or notice required. I think it should be
Sorry, just tell us which clause in the bill you're referring to.
In regulations, when you come down to section 15D, I believe, right? It says relating to the giving of any notice required or authorized to be given to any person by or under this act.
All right, so you're referring to clause 15. The minister may make, that outlines how and under what conditions the minister may make regulations. So the minister may make regulations relating to the giving of any notice required or authorized to be given to any person by or under this act. So what this is saying is that the minister may make regulations for this purpose. So what is your comment on that?
Right. As it relates to giving notice, I think there should be a set period or a set time that the minister has to operate within, as opposed to using discretion, at least a minimum time.
Right, so I think all this is saying here is that the regulations that are to come, that will be laid by negative resolution, would speak to the notice required. So the regulations that will be made under this legislation will speak to the notice required. This does not specifically say that period will be discretionary.
Okay, thanks. Okay, part 4, which speaks to miscellaneous. They spoke to the minister's discretion not to be questioned and decisions to be final. If you were speaking about the above section, I assume that you would have not seen a closed-ended sentence where the sentence was finished. This part 13, the sentence was finished, and then you started a new sentence was speaking to the minister's discretion. So I am assuming that that does not correlate to the section above. And then under that, it says 13, it said that the minister shall not be required to assign any reason for the grant or refusal of any application under this act, and the minister's decision shall be final. So my concern there would be the blocking of access to judicial review. I assume that if such a clause is challenged in the law courts, it may be struck down, because I don't think that a minister's say or power should be final. I think that the law courts and the judiciary should determine the final aspect of it, right? So if I want to protest a minister's decision, I should have somewhere to be able to protest that decision. Also, this bill, well, it speaks to the granting of citizenship. It has expansive information on it in terms of depriving people of citizenship as well. So I was looking at this bill, and you spoke about the negative resolution aspect of it. So due to the fact that the minister has, I would say, utmost discretion, and you don't necessarily require further parliamentary approval to make specific decisions, I am concerned that at a future date, there may be the possibility of the abuse of the bill for a minister to determine who should or should not be deprived of citizenship. Now, in the Middle East, you have countries that take over other countries and other people's land and render natives to be stateless, right? So you should guard against the possibility of such an action. You should also guard against the possibility of actions taken, like if you're not a born person in Barbados, even if you're a CARICOM or Commonwealth citizen, by virtue, like there's a possibility that your citizenship could be revoked under, specified future laws. To move on quickly, there's an aspect in here that speaks to speech and acts under which a minister could deprive somebody of their citizenship. And this is at 13, section 13. It says that the person who has shown himself by act or speech to be disloyal or disaffected.
Sorry, which clause?
This is 13, and what? Well, I'm going to repeat the clause. I said, because it's calling for in terms of depriving people of citizenship. So I might be giving you the wrong number. There's a possibility.
It starts
At 9, right? But the clause which says that the person has shown himself by act or speech to be disloyal or disaffected towards Barbados.
That's 9C, clause 9(1)(c).
Sorry, that's my bad, not 13. 9(1)(c). Right. By act or by speech to be disloyal towards Barbados. So again, one person, meaning the minister, has the determination by somebody's speech or by act. So to give the public some comfort, there are words like terrorist activities that could be included, right? Because this is broad. This could be speech or act, could mean anything. This is minister's determination. So disloyalty could also be very broad and interpreted very broadly, right? So I would appreciate something more specific as to what exactly is disloyalty and what exactly is disaffection towards Barbados, right?
If I could perhaps give a little more context to what you've just shared, because this came up in our discussions when we met on Wednesday. Just to point out that this relates to people who have been granted citizenship by virtue of the sections quoted at 9(1). Other than by virtue of the sections quoted at 9(1), related to the Constitution. So this is not somebody who is granted citizenship by birth and by the other attributes that are highlighted here. So this is somebody who's granted citizenship under the other conditions. I just make that stipulation to say that a person who speaks, who by act or shows themselves by act or speech to be disloyal or disaffected, who is born in Barbados, who becomes a citizen of Barbados under the Constitution, that this does not apply to those people. So this is in cases where this person has been granted citizenship under other conditions. So I wouldn't want the public to be of the impression that any citizen of Barbados born here can say something and be stripped of citizenship, because this is not what this relates to. But please go ahead.
Right. But thank you for the clarification. It was listed above in section 2345(1) or 2. It says, in the bill. Just to repeat what you said and confirm what you said, right? However, again, you may grant somebody the citizenship, but again, if you minister wake up not feeling good or angry, and determine that this person does not. So it's too broad, regardless of if it's somebody here or that has been granted the special citizenship. It should be specified specifically out of terrorism, human trafficking, treason, etc., etc. Also, I was wondering how come it was a bill based off negative resolution. Hey, how come? Because, it's about Barbados, and I feel like it should kind of be open, not necessarily going this route. Right? So.
Sorry, the last point you're making, that the regulations will be introduced by negative resolution? Is that what you're making?
Say all regulations made under this section shall be subject to negative resolution. So it was listed as the same example that I made previously, where you finish a sentence and then you went on to another line and you stipulated this specific thing. So I wasn't sure if it was related to the section above, or was it the entire.
Can we ask the CPC to clarify?
Good morning, everyone. I believe what might have happened is that what you're seeing as an incomplete sentence is actually what we would call a section heading. So it just speaks to what the content of the section. So for example, when you mentioned section 13 in particular, I think you started off by saying that there was an incomplete sentence, and then the provision went on to speak about the minister's decisions. But if you look at it, it's no more in that section than just a summary of what the section contains.
Okay. All right, thanks. Right, so that is my final comment on the citizenship aspect. And I will also just wrap up by saying that I don't think citizenship is something that we should willfully gift. I don't think we should reduce the barriers significantly. I know we want to increase the population. I know we also want to attract persons, both working class and wealthier persons as well. And, some shifting is required. But I won't try to drop the bar too low, because Barbados's passport is a very powerful passport in the entire globe, and it would want us to maintain the status of our passport and not be perceived by global powers as trying to find ways to, shuffle passports into other persons of other nationalities' hands and then you hear the allegations. So I would want to protect Barbados from that. The immigration bill, specifically section 7, which speaks to permanent residency now. It says, subject to this act, a person who, by age, Barbadian descent, education, skill, experience, or financial resources, or in any country as a member of staff of an international organization. So in the definitions, an international organization is determined again by the Minister for Home Affairs, right? So I would like to have a list from the Ministry of Home Affairs included in the bill of all our international organizations domiciled in Barbados, right? So we recently have the launch of the Afrexim Bank, which is, I would assume, is an international organization. So that should be listed in the bill, which speaks to people gaining permanent residency, right? The aspect of financial resources, to me, this is a soft introduction to citizenship by investment. Right? So if you have adequate financial resources, you gain permanent residency status, right? And then you go on to becoming a citizen if you have adequate financial resources.
Well, just a clarification. Remember, sorry, I'm trying to find the clause that you're making reference to, but remember that the point system that is referenced is a combination of skill and education, age, assets. So it's not simply, you're not granted permanent residence or citizenship simply based on financial resources. So I just wanted to clarify that, give some context to your comments.
Yeah. So is it determined by multi factors? So to say age, descent, education, skill, experience, or financial resources. No, to be able to garner financial resources, you have to have a skill. You have to be skilled, right? To have financial resources, I would say, and legal financial resources, right? So it's like potato for me. Now, if you do make it to Barbados and you have the financial resources to do so, you are here as a permanent resident. So you are in Barbados, the minister or the immigration department determined that you have adequate capacity to support yourself, and then again you are on to the permanent residency aspect. If you wait a little bit of time, then you become a citizen and you have a passport again. So again, I am concerned that it could be utilized. Right? I am concerned that it could be utilized if left up to the minister's interpretation, right? Or a small group of people's interpretation, as you say, based off skill, experience, and financial resources.
Okay. I just want to make sure that you're understood so that when we come to our discussions that we can make reference to what you said. So you're saying, bearing in mind that this is a point system, and so one of the things we discussed in our session on Wednesday was that perhaps we would have liked to have the benefit of the regulations to understand exactly how the points will be applied in the case of, especially in the case of skill and education level, right? But bearing in mind that it is a point system, right? It is a point system that allows you to qualify for permanent residence, and then after some time of being a permanent resident allows you to qualify for citizenship. So can you explain for us one more time, what is your particular observation on that?
Right. The point system, as you say, will be based off a few things there. Assets, etc., etc. But I made the point earlier that to be able to have those assets, you have to have a skill, because an unemployed man can't turn up at Barbados' doors with $2 million in assets and we don't know where he got them from, right? And we look at other aspects to determine if he should be let in or not. So I would say that you're a skilled person, and you utilize your skill or your education to earn income, and you build that income to a specific level. And an unemployed man can't be treated that way, because if you are unemployed with, again, $2 million in assets, something definitely wrong. So I am looking at the fact, again, that this specific section, along with the points, because the point system, again, is determined by who, right? And the point system is built on the fact of investment, real estate, and other economic goals, right? So only persons with a specific amount of money, one, can be able to afford to come to Barbados and be able to live in Barbados, right? So again, is it a soft way of introducing, if you don't want to say citizenship by investment, there's a specific program which deals with high net worth individuals, a special permit that the government issues, right? So this particular section, to me, is in the same kindred spirit, and if utilized correctly or incorrectly, it could be interpreted again as a soft introduction into citizenship by investment.
Okay, so I think we wanted to have some discussions on your premise there. I will speak, and then I think Senator Boyce wanted to speak. I'll just say something very briefly. You've established a premise with which we may not all agree, which is this notion that what you're suggesting to us is that the other categories of age and skill level are inconsequential, because if you have money, that means that you have a skill. But there is a contradiction inherent in what you've just said, because the point is, one of the parts of the due diligence that the administration will have to carry out is exactly what you said, to make sure that you don't have money that you cannot justify or substantiate. That's what the administration will do for anybody. That this is what we do for citizens as part of the judicial system. How is it that you've come to have these funds or these assets if you cannot show how they've been accumulated, rather by gift or by inheritance or by work or by some other way. We have to do it when we fill out, when we complete a source of funds form for the bank, right? So you would imagine then that under an immigration regime, that a person would have to do that. So the notion that if you have this money, you must have a skill is one that would have to be tested anyway, right? So remember, this is a point system. So there will be people who might qualify, that qualify by virtue of skill and qualify by virtue of age, but not by virtue of assets. You follow what I'm saying? So to suggest that everyone qualifying will be qualifying by virtue of assets or financial readiness is incorrect under the law. Is incorrect by the way the law is laid out, because it is a point system. And if you're familiar with what happens in Canada, and again, this is me trying to establish your context and your premise. I'm not arguing the substance of your point, but I'm saying if you look at what happens in Canada, there are many people who qualify that do not have financial assets. They qualify because they're young enough to be able to work for a certain amount of time in a sector or with a background that Canada, as a sovereign nation, determines that they want to have. So I don't think that your premise is correct to suggest that people will be coming in only on the power of their financial assets. But I'll let Senator Boyce come in. Yeah, so I think that the premise is what we might have a difficulty with.
Yeah. Sorry if you misunderstood my premise, or sorry if I didn't communicate it properly either, right? But I don't think that you could only enter on your money alone and your skill, right? So I believe that you are correct in saying that the age and other determinants could be used. No, that's fine by me, the other determinants. But in terms of the aspect of the financial part, there are instances where money laundering is a serious thing, right? So you have businesses, and you see a section in the bill that speaks specifically to business providers and service providers, specifically coming out to the EU member states, right? And as we know, Barbados had some serious challenges as it relates to the blacklisting issue, right? So I just want Barbados to be in a safe position as it relates to the possibility of money launderers utilizing any possible loopholes, right, in terms of the financial aspect.
Right, but you do realize that precisely because we have strengthened our AML, anti-money laundering regime, and been able to come off of those lists, puts us in a position now, and we've done that because we've strengthened the level of due diligence that is applied to these individuals. So what I'm trying to communicate is that with or without this legislation, so set aside this legislation, right? An individual is not able to move assets, to claim ownership of assets, moving from one jurisdiction to another without some investigation into how these assets have come to be in their possession in Barbados as a jurisdiction. That can't happen even today. So it will also not be able to happen when this legislation is in force. So this is all for the purposes of clarification, because I wouldn't want anybody to think that all of the work that has been done to strengthen the AML posture of Barbados now disappears because of this new legislation. As a matter of fact, I think this legislation is made stronger by that enhanced AML regime that has been put in place. Just for context.
Fair point. Right, so I'm going to wrap it now. I am lastly concerned about persons entering Barbados, because there are rumors about that persons have been entering into Barbados' space and having offspring or children, right? Which would then, having the children born in Barbados would then give them access to some type of benefits or so. So are there any specific clauses that could give us some comfort as it relates to saying that if you know, are over I'm trying to not think, but if you are over a specific point in your trimester or so, that, you know, there should be some rules that speak to that. Or if you have a baby here in Barbados that don't necessarily come from Barbadian parents, that you should take on the nationality of, you know, where your birth parents come from, so as to stop any possible abuses of Barbados' system. And last point now, does the bill open space for Barbados to flex its arm as it relates to tackling any possibilities for human trafficking? Right? Where in the EU, I would have visited Ireland and observed from there and some other EU states where there's a problem of migration, where people take boats and other means and ways of getting into these countries, some taking refugee status, etc., and then they are granted benefits, which are funded by the taxpayers. And many natives in those countries have serious problems with that happening, and many EU governments are crying out right now as it relates to over-migration in this space. Right, and that's it for me, thank you.
Thanks very much. I think just to make a couple of comments on the last point. So really this is just to get it correct for the record when we come to our deliberations. So you are suggesting that we revisit the issue of birthright citizenship, like meaning that you're here, you have a child who was born here, and that being born here should not automatically confer citizenship? Is that what you're saying?
Well, the intent behind it is my concern. Whereas, for example, if you have a pregnant lady, not all of them will show, you know? So you can't necessarily look and determine, well, a lady is 9 months pregnant, or 8 months pregnant, so she should not be allowed to travel. Right? So I said the intent is you intentionally left the country where you are living, and you came into Barbados with the intention of having a Barbadian baby, right? Mm-hmm. To have that baby given access to whatever.
Mrs. Stewart, how pervasive do you think this practice is? So let's create a scenario. You are a pregnant woman, right? And I think most doctors and jurisdictions have kind of guidelines for the term, you know, how the period beyond which you are able to travel, you know, in general. But then let's move beyond that to a scenario in which a woman who is pregnant, who already has provenance, has a family, has a life in another jurisdiction, decides, you know what, I don't know anybody in Barbados. I'm going to leave my country, my family, my friends. I'm going to get on a plane and I'm going to just decide that I'm going to come to Barbados and have my baby. Now, pregnancy and childbirth are already vulnerable, a kind of a vulnerable activity, right? So it is not like coming and getting a dental checkup. You really, a woman will want to be assured that she has access to a certain level of care. And it is not, I imagine, a decision that would be taken lightly to leave your country and just decide to come to Barbados and have your child here. So that causes me to ask you, how pervasive, statistically, how common do you think that this, because we already have birthright citizenship, right? Already. So if this were to happen, it would already be happening, right? We have all seen the speculation about this idea of childbirth tourism, this idea that people want to come and have access to a certain level of care that Barbados offers, which is a different debate, which perhaps based on the small numbers that we think might be coming for that purpose, infinitesimally small numbers, really perhaps do not represent a risk, right? So how prevalent do you think this is today when already you can come here and have this legislation does not open that up, that already exists? How prevalent do you think that is?
Well, I mean, it's extremely prevalent because I saw on social media, right, a company specifically advertising those services, right? And I posted it on my social media as well.
And you consider that because a company is advertising those services, it is extremely prevalent? I think that you're an economist, right?
Some say not, but, you know.
Don't worry, some say not, but me too.
Yeah.
But thinking of the statistical prevalence of it, like one in how many thousands?
I can't call a number off my head. Right. But from my research, I have spoken to some doctors in Barbados, some senior doctors in Barbados, and the practice is occurring, right? It is occurring. So it was raised to me also as a concern from within that space as well, from in the medical space, you know, quietly. So I would consider it as something to look at. Maybe it may not be a big problem immediately, but as the legislation is a futuristic type of legislation as well, future problems do arise, right? So again, I say when I visited the EU, like, the immigration problem didn't start as it was, like, it started out small and then it morphed into being a grand old problem. So before it gets to being a grand old problem in Barbados, right, it's something to definitely look at and to put any slight preventative measures to stop it from getting out of hand.
Understood. Sorry, I just wanted, you mentioned two things before you come in, Senator Springer. You mentioned the birthright citizenship issue and then you mentioned human trafficking. Now, the legislation addresses the question of how a person lands and is regularly processed through immigration. So to say that it has to be a recognized air or sea vessel and so on. So already that kind of activity would be outside of the law, right? So that would be outside of the law. But then the legislation also speaks specifically to, and CBC may have to help me to find and to quote the clause, but it also speaks specifically to how people who are trafficking in persons are to be treated under the law. So the legislation does make provisions for addressing trafficking in persons. I don't think that there's any further it could go to be able to do that. Is there some specific suggestion that you're making?
Well, it's the part I spoke to the actor, right? The person who would be, you know, the brainsman, the comptroller, the captain of the vessel, anything like that. But we didn't really select the victim aspect of it, where, for example, somebody had to smuggle people in Barbados on the ship, right? And the persons came here unregistered, etc., etc. The legislation speaks to prohibiting that sole person. Now, let's just say that these persons happen to make it off the ship and make it on land, inland, etc. Then how do you treat those victims?
I'm glad you said victims, because that's what they are. Yeah. Now, again, we're taking evidence from you, and so I know others will have responses, so I don't want to make this a debate. But I think that Barbados certainly has a philosophy in terms of how, and especially depending on the provenance of those individuals, right? Whether they're members of CARICOM, who knows where they may be coming from, but this is a humanitarian concern. The question of people who have been trafficked is a humanitarian concern that requires a humanitarian response, not simply an immigration response. You would agree?
Yeah.
Yeah, so I think that, one, in my decades as a Barbadian, I haven't seen too many people claw their way off boats onto the land to seek refugee status, right? But even were that to occur, I think that that we have to be guided as a jurisdiction as well by the question of how do we treat people who are homeless or stateless. How would we want to be treated in such circumstances? We see, and we are not the EU, we are not overrun in any ways by anybody who's seeking to come here off that kind of vessel. So I wouldn't want us to kind of, create straw boogeymen that we then have to knock down. I think that the legislation does speak to, I think we are right to understand that those people are victims and that there is a perpetrator in that case, and that it is likely that if you address the problem at the level of the person who is carrying out the illegal activity, that you're likely to be able to disincentivize the illegal activity rather than targeting the victims through your legislation. So, I mean, I think your comments are noted. CPC will want to come in. Sorry, Senator Springer, then you'll come in.
Just quickly, because I think I wouldn't want to belabor the point now, because I think you address the matter that was raised by my colleague over there. I just wanted to caution him about what he was actually asking, what he's saying, and what females or what a woman will be hearing. This is basically that we'll be barring persons from entering into this country if they're pregnant, under the assumption that they may be seeking benefits of the country as a result of child having been born here. And I think it's too late now because the discussion already took place. But very few countries in the world even consider that as a measure in terms of barring pregnant women. Of course, at a certain age, for medical reasons, women are not allowed to travel on planes. Maybe the airline may speak to it, or the doctor may suggest that they not travel on airlines. But to say, let's say, for example, a young lady or a young woman who's 2-3 months pregnant, because then you have to determine how far along that person is. At what stage would you make the determination that you're gonna ban or bar that person from entering into the country? And I do not think that we as a country want to go along that path, even though it sounds all well and good in discussion. As a man saying that in the presence of a female or for women to hear, you say that, if you're pregnant, Barbados would not be allowing you to come on shore, or wouldn't be allowing you to come into this country because we suspect that you may very well be looking to benefit from whatever benefits accrue to children who are born here, to persons who have citizenship through childbirth. I don't think that's something that we should be saying. That I wouldn't say. And I was going to suggest pretty early on, before we got into the discussion, that we not try to debate that, because it doesn't look well.
Thanks for conveniently leaving out the parts that he mentioned, where he said that if you are past a specific point in the pregnancy where you are liable to be in labor very soon. So not necessarily barring pregnant women in totality, but for example, you see, you have to fill out information forms beforehand. I think it should be declared on the form. Are you between non-medical doctors, or just giving a point? If you are between, say for example, 7.5 and 9 months pregnant, at least the government of Barbados, and you're looking to be in Barbados over a specific period, I think the government of Barbados should be aware. Because at the end of the day, regardless of how you look at it, the child will become a Barbadian citizen. Right? So that benefit, and this is the reverse of what you're saying, that benefit is not rolled out worldwide to many countries as you would have stipulated. So it make Barbados any different, because don't get it twisted, women are involved in criminal activity as well, right? Not just men. So there are women up there who are involved in terrorist activities, involved in human trafficking activities and involved in other activities detrimental to national security and to the general public order of Barbados. So,
Okay, but you kind of conflating two things. Pregnancy, women who are pregnant, and then women who are looking to engage in criminal activities. Pregnancy is not a criminal activity.
no.
Right. So you start in one place and you ended up in another. I think maybe just to close on the point, I don't know if you want to come in on another point, but maybe just to close on the point, we have to be careful, right? A woman's reproductive status is not a question of public information, right? Because I could be pregnant now and you wouldn't know, right? So the notion that a woman must declare her reproductive status, you're starting to get us into waters that I would urge you to consider, just as a general point, right? Because, you know, there are right to privacy issues that come up. So the universe of things that you can ask somebody to declare at a border for the purposes of entering a country is not infinite, right? And I would want us to not forget as well that the immigration personnel have a function. We are acting as if everything is done through the power of legislation, but there's also the practice of policy at the border. And really, the legislation will speak to the information to which the questioning to which you make yourself subject when you land in another, at the doorsteps of another country. So immigration have the job of satisfying themselves of a few things. They have to satisfy themselves as representatives of the state, that you have sufficient funds. So sometimes we all travel. We know that sometimes an immigration officer will ask us lots of things. They'll ask us to produce documentation. They'll ask us questions. And that conversation occurs between the person traveling and the officer at that point. But we can ask people to make all kinds of declarations that will stay in the statistical information of the country for 7 years plus, just because 4 women from a particular country travel here to get the care of a particular doctor to have their children. That's how, I mean, the assessment of risk is also down to the statistical prevalence of a thing, right? So the fact that 3 people or 4 or 10 people have done it doesn't constitute risk, right? So, I mean, I think that just again, to give a little context to the conversation, you wanted to wrap up on that point?
Yes. So, if you come into the country and you do not declare, right? So, and for example, you do fall into, you water break and all that stuff, you have complications with the pregnancy, then you still have to come to use our systems and our services to help at the specific time. So it would help the country in a significant way if at least we know the government is aware or so. Now, if you, in terms of gender, right, because you mentioned the point about information that you would declare on a paper. Now, when you go into any country, they ask you if you're a male, female, whatever gender or so. And some people argue that their gender is their business, right? So they can say that how much they feel. But when you get presented with that immigration form, you have to fill over on this paper or, run the risk of not being allowed into the country. So we're not setting up things for detriment or to bring harm. We're setting it up for, one, the protection of Barbados' system and resources, right? And to also to keep these risks that we speak about at bay so that, again, they don't become runaway problems in the future.
Mr. Stewart, you could come to Barbados as a tourist and get hit by a car and have to go to Queen Elizabeth Hospital. So, again, reproductive status is not relevant there, because if a woman has to present for healthcare for any reproductive reason, because pregnancy is just one, But if a woman has to present for the care of the state for any reproductive reason, then it is whatever reason she has to present. So you're saying that, oh, well, a woman should say whether she is pregnant in case her water breaks and she has to go to the hospital? So should you say whether you intend to drive a car? So in case you get into an accident, should you say whether you intend to climb Mount Hillaby in case you fall off? So, I mean, look, again, I think your point is very, very noted. And I don't want us to go further and further down this rabbit hole. Yeah, I do think that what I would say as a general point is that not everything that you can't ask a person to declare any attribute that they possess just because they're coming to your country. Data protection laws will not even allow you to do that, right? And I'm suggesting to you that the risk that you are suggesting is perhaps not as great a risk as you might believe. So I think with that, we might be able to close on that point. Any other? Sorry, Senator Boyce and then CPC. Is this something that is going to help? Because I don't want to wait too long if this is something that's going to help bring clarity to our discussion.
Thank you, Chair. It was just to clarify the position of the victims of human trafficking, since Mr. Stewart mentioned that a woman could have been trafficked and then be pregnant and then have the child in Barbados. So I just wanted to add some clarity in terms of the law as to how Barbados treats victims of human trafficking. There is trafficking in persons prevention legislation since 2016. And Barbados has undertaken to provide housing, training, counseling, even assistance to remain and work while, for example, there's a prosecution going on against the traffickers. So the chair has already spoken about the policy, but I'm just adding what already obtains in the law.
So could it be included in just a mention of it in the bill? In terms of the human trafficking legislation?
Well, the reason that we would advise against that is that the laws work together as a body. Just as easily as you're saying, perhaps we should mention the trafficking persons legislation, unless there's a fundamental reason for doing so. There are other laws that we could also put into any particular piece of legislation that we draft. But it begins to become a little bit voluminous, unwieldy, difficult to manage. So in some cases, if a cross-referencing is necessary, as a matter of drafting, we do that. But if it isn't absolutely necessary, we rely on public awareness campaigns, persons doing their own due diligence, finding out what the law is, because there are so many.
Senator Boyce?
I want to take you back to the immigration legislation. You expressed a set of views here around our concerns, rather, related to the power of our passport and kind of sharing it away. My words, not yours. And you've expressed other concerns. My question to you is, what in your party's view, should an immigration regime look like? How should we? Because you also expressed concerns, or some concern around the point system. So my question to you is, what should that regime perhaps look like? Do you have any suggestions for what a regime of that kind should look like?
Well, I believe in immigration for economic reasons. Barbados at this specific time it has a regime in terms of immigration. So my recommendations would be to not necessarily lower the standard for to being a complete citizen. You could lower the standard for work permits to some degree. You could lower the standards to having residency. to some degree as well. But you should maintain the barrier for being, as I said, outright being declared a full Barbadian. Because Barbados does not have like alien landholding acts or protectionism really over various aspects of factors of production in Barbados, right? So you don't want to create a situation where Barbadians feel as though immigrants would come and have, access to, once they have the financial capital or otherwise access to the resources before them or so, right? So if you want to go the route of open borders, etc., you should look at having some type of, as I said, alien land holdings or alien holdings over some Barbadian assets to stop a possible, stop a possible, I don't want to use the word fight, but I would say dissenting views, serious dissenting views about having immigration. Because they support people coming to Barbados, right? But as I said, the use of the passport needs to be protected, and also other Barbadian assets also needs to be protected from over-exploitation from persons coming into the country who may have the wherewithal to have access to things first before Barbadians.
Do you agree with me, or is it your view that a person coming to Barbados, that the criterion for holding assets is an important criterion for the determination of citizenship?
If you're trying to encourage business and capital and investment into the country, a proper structure is attractive for persons who may be interested.
And should the holding of financial assets be a part of that proper structure, as you see it?
Yeah, if you're trying to attract high net worth individuals and persons of means, because you can't only attract working class people, you need to think from the perspective of that there are some persons who may have bright ideas, capital intensive ideas, and assets, etc., that goes with those ideas, and you want to attract wealthy persons into the country as well. Barbados did it previously, where we had the exempt surplus arrangement, where we repatriated dividends between here and Canada. And then you had the emergence of wealthy Canadian businessmen who came into Barbados, set up the businesses, they then came in behind that capital, and then you had a lot of Canadians coming in, being attracted to those high net worth individuals.
Does that submission defeat any of your earlier submissions this morning?
No, because I did not specify that that just having money is a problem. I never said that I don't want people with money. Hey, I said you have twofold: the working class and the high net worth individuals. Hey, so I'm not anti-investment or anti-capital, but I am pro these things with safeguards.
Thank you, Madam Chair.
Any other questions for Mr. Stewart? Okay, if not, let me thank you on behalf of the committee for coming to give evidence to us and to let us hear your views. The Office of the Clerk has asked whether you'd be willing to summarize some of what you shared today in writing to share with them, but be assured that everything that you have entered into evidence today will be a part of our deliberations going forward. So thank you for coming.
Yes, thank you very much. I'd like to thank everyone who was here today. Thank you for the questions. Also like to thank the online viewers, and to thank the party, the New National Party, for facilitating the opportunity for me to be here today. So thank you very much, everyone.
Thanks, Mrs. Stewart. All right, thanks, colleagues. According to the agenda, then, we would now come to consideration of written presentations, written submissions. So we have a list of 10 written submissions from individuals and institutions. I would like to suggest that we review the overall content, the areas that these submissions address. If we start with the submission from, well, the note from Ms. Tricia Watson that came to the Parliament on the 16th of October, Ms. Watson really makes some recommendations for the general functioning of the Joint Select Committee. And as you'll see from your copies, she recommends process issues like suggesting that a deadline for indicating that a person wishes to make a presentation, an in-person presentation, be stated by the office of, by the Parliament. Notice of the dates when the committee will sit being published. We realize that those dates are not always known in advance because they also rely in some ways on the availability of members and on the availability of the precincts of Parliament, quite frankly. So I think that the recommendations are well received. And I do think that for the general functioning of the Joint Select Committees, that these are things that can be adopted once all is put in place for them to be adopted. So Ms. Watson's recommendations are well received and we thank her for them. Sorry, there's also a recommendation that the response time frame be no less than 21 days for matters that are placed, for legislation that's placed before the committee. Anybody has any questions or responses on that? We have a submission from Ms. Annabelle Pemberton, who wrote on the 21st of August of this year. And members have the submission before you. Without reading it into evidence, Ms. Pemberton is making reference to the expansion of citizenship by descent to include grandchildren and great-grandchildren of Barbadian citizens. She makes reference to the fact that her grandparents were born in Barbados, as were most of her aunts and uncles. She talks about the fact that Barbados has always felt like home to her in spirit. She's a regular visitor. She talks about her profession as a history teacher, whose work is tied directly to Barbados and the wider Caribbean. specifically on the history of formerly enslaved people, and her work placing Barbadian and Caribbean narratives at the forefront of historical inquiry. Ms. Pemberton says that she supports the proposed expansion of citizenship by descent. She says, quote, "Families like mine with deep roots in Barbados are eager to contribute to the island's future, not only economically, but culturally and academically. This reform would allow me to live, work, and raise my future children in Barbados, bringing my skills and passion back to the land my grandparents called home," end quote. So this is a submission that supports the expansion of citizenship by descent to include grandchildren and great-grandchildren of Barbadian citizens. This is small handwriting. We have a submission by a Lucy McHale, sent on the 21st of October, 2025. Ms. McHale's submission relates to some of the broader factors that have to do with how citizenship can sustainably, and immigration can sustainably be expanded. She indicates that she and her family are currently in their 5th year under the Welcome Stamp program. And the consideration here seems to be about what are some of the attending factors. So at one, pathway to long-term residency, she makes reference to the creation of a clear pathway to transition from the Welcome Stamp to a more permanent immigration status. I think you'll find from some of the written submissions that this is not the only one that makes that reference. So the question is, how do long-term residents under programs such as under the Welcome Stamp make that transition? I think that is accounted for, I believe, with respect to how long a person has been resident. But I think that it may not, the legislation would not hurt from being perhaps more explicit in making reference to the Welcome Stamp. The second point made is the question of access to quality and affordable education, and the extent to which quality control of educational services should perhaps be considered as a part of not of this regime, because I don't think it fits in this legislation, but I think these are broader points about sustainability of having more residents here and what they will require and what the people who are likely to move to Barbados for some of the purposes that we would want to encourage, what they're likely to demand or to expect, what people's expectations are likely to be. In that vein, the submission also makes reference to housing and financing options, making reference to high rental and housing prices, limited housing availability. It makes reference to access to preferential mortgage rates. I do not know what we mean by that, because I think that whatever are the reforms that we introduce in any sector must obtain across the board, and certainly for Barbadians who have always called Barbados home, and not in any preferential way for people who are now coming to make Barbados home. And at 4, support for business incorporation, which I think goes without saying, that we need to strengthen the framework for investment. I don't know why Senator Walters is looking at me like that. We need to strengthen the framework for investment and for the establishment of business, both for people who are already here and those that we might be seeking to encourage. So I think that these are, I would not contemplate that these provisions would be accounted for under the current legislation, but certainly there are considerations. I would also want to say here, though, that Government of Barbados commissioned a population study and a population policy. And for us to consider this legislation outside of the framework of that policy would be doing a disservice to the work that was done and to the intent of that policy framework. The population policy speaks in a holistic way to what is required in order to sustainably grow the population of Barbados. It assumes that there are concurrent investments required in people, in infrastructure, in environment, in the ways that we live and work, in order for this regime to work for those who live here and those who might come. And so I think it's important for all of us to understand that this legislation is not existing in a vacuum, and that the population policy, in many ways, talks about how do we make sure that we are first not marginalizing or further marginalizing any of the people who are concerned who are already here. And I encourage us to always consider what we are doing here in the context of that framework, because it quite frankly suggests that simple measures to increase numbers will not take us where we want to be, that there have to be these concurrent actions, many of which government has already initiated, in order for this framework to have the impact that we want. And I think that this submission bears that out. So we move now to Akil Murray. Whose concerns, some of them have already come up in our discussions. Just to summarize, with respect to the Citizenship Bill, ministerial discretion and finality of decisions. The bill states that the minister's decision shall be final and that no reasons need to be given. This eliminates transparency and the applicant's right to understand or appeal decisions. The recommendation is that refusals and deprivations be accompanied by written reasons and subject to limited appeal before an independent review committee or the High Court. The phrase "not conducive to the public good," forgive me, but the submission does not make reference to this specific clause. The phrase "not conducive to the public good," Mr. Murray considers that the phrase is undefined and open to subjective interpretation, and that there be clear and objective criteria. The term disloyalty, I think that is at 13. Can you help me? I think that was referenced in the earlier oral submission that we had. Is that 9(1)(c)? That Mr. Murray considers that this is a broad term, and it could encompass legitimate political expression, and that recommends that there be some limitation on the grounds for removing citizenship that relates to perhaps acts that endanger national security or constitute serious criminal offenses. Again, economic and security screening, Mr. Murray considers that likely to become a public charge risks economic discrimination, and that there be some objective financial benchmark. Moving to the immigration bill, reference is made in the submission to ministerial control over entry and residency, and it questions the wide powers of the minister to refuse or revoke residency on national security or public policy grounds. I don't want to editorialize on the submission, but I do think that national security grounds often cannot be transparent and shouldn't. And the recommendation here, however, is that an appeal tribunal be established in cases where residency is refused or revoked. The submission also asserts that the point system for permanent residency lacks clarity on weighting, documentation, and thresholds. I think that this point was made by us as well in terms of the regulations and how the points will be allocated. Mr. Maurice suggests that officers may arrest and search without warrant. I'm not sure what clause he's referring to in the immigration bill. And that detention periods are not clearly limited. And that procedural timelines, that we could set procedural timelines for all judicial matters. But that procedural timelines be set. Deportation and right to review. Contention here is that deportation orders take effect quickly with limited opportunity to appeal, and that the appeal window, as quoted in as stated in the legislation, be extended. Okay. We have a submission from a Mr. Peter Thompson, sent to us on the 26th of October, 2025. As a summary, Mr. Thompson likewise suggests that there be a clear pathway for the welcome stamp visa to be converted into permanent residence and/or citizenship. His suggestion is that there be a clause introduced that stipulates that 3 consecutive years on the welcome stamp visa will be worth up to 3 points, and 5 consecutive years on the welcome stamp visa will be worth up to 5 points. I think that's the summary. Let me just get the name right. Dr. Antonio Joyette. Overall, Dr. Joyette's submission suggests that there's too much ministerial discretion in the legislation without sufficient safeguards. There's a lack of an independent appeals process. There's limited protection for immigrants, asylum seekers, and vulnerable individuals. There's inadequate privacy and data protection concerning passenger information systems. However, as the CPC has indicated, there are other pieces of legislation that govern the functioning of this legislation that are not explicitly stated here, the Data Protection Act being one of them. And also, Dr. Joyette suggests that there is weak connection between immigration policy, national development, and diaspora engagement strategies. Again, I don't think that the legislation itself can speak to that connection, but certainly that the overall policy framework can. Specifically, it is recommended that an independent immigration appeals tribunal be established. I think that as a part of our deliberations, certainly we will need to have some research and background done on precedent in other jurisdictions, especially other jurisdictions that may be part of an economic or geographic union like ours, but also other jurisdictions that have managed migration regimes, so that we can have reference to what is done in other jurisdictions. You know, in many ways, the difference, this is my personal reflection, the difference between immigration and citizenship legislation and other kinds of legislation is that apart from the granting of citizenship or the right to citizenship under the Constitution, the granting of citizenship is like an invitation for someone to come and visit or stay in your home. There's no explicit right to be able to leave one jurisdiction and take up residence in another. But you have to be able to satisfy the homeowner that you mean no harm and that you will add to the well-being of the environment. So in some ways, there will be some measure of discretion. Because there's no international right to move freely to any jurisdiction. And so there will be some extent to which a country, a sovereign nation, will have to make a judgment about the capacity of a person to be able to add value or at least do no harm in these circumstance. And so it is important for us to be able to reflect on other jurisdictions and what they have done with respect to appeals, especially for immigration purposes, to be able to say, well, I'm not allowing you to enter on this occasion. If we find that we then have to justify to every person who may be entering why I'm not allowing you to enter on this occasion, we may find ourselves in a real kind of bureaucratic piling on that does not allow us to continue the work of the office. This is just a reflection of mine because I consider that the question of immigration and whether somebody can enter is perhaps different from a rights perspective than many other things that we might consider as a committee. And that is just with reference to this idea of the question of appeals and how those might be done. Certainly, I think that appeals that relate to residency, to citizenship, may occupy another space, but simply to immigration matters, that's one for our consideration. The submission also relates to the definition of ministerial discretion and recommends a clause that requires the minister to provide written reasoned decisions and that legislates the publication of those decision-making guidelines. Again, we can deliberate on that. It also speaks to the introduction of explicit data protection and oversight provisions, incorporating of humanitarian safeguards, rationalizing penalties and distinguishing victims from offenders. This came up in our discussions this morning. And enhancing transparency and parliamentary oversight. The submission also goes on to suggest a broad-based, long-term managed migration and skills strategy over 10 years, a diaspora engagement and investment framework, and the introduction of specific visa categories depending on the industrial policy of the country. It finally suggests implementation and oversight mechanisms through looks like it would be essentially a subcommittee of cabinet or a cross-ministerial committee, including the Office of the Data Protection Commissioner. Just to clarify that the submission just referenced was by Dr. Antonio Joyette and Cheryl Joyette. Submission from Stephanie Holder, who supports extension of the laws governing citizenship by descent to include, sorry, let me start again. Ms. Holder is writing to request consideration for an extension of the laws governing citizenship by descent to include the grandchildren of Barbadian citizens who were citizens from birth. Is that? Ms. Holder also indicates that she has initiated a petition that has gathered more than 500 signatures from individuals across the diaspora who share support for this reform. She says, I respectfully urge the passing of the Barbados Citizenship Bill 2025 as soon as legislatively possible to realize the full economic and social benefits detailed herein, which include skills transfer, generational loyalty, repatriation of capital, and increased investment. We have a submission from Senior Counsel Edmund Hinkson. Let me attempt to summarize. Mr. Hinkson makes reference to the Barbados Citizenship Act, Cap 186, which presently provides that an adult citizen of any country mentioned in its first schedule or of Ireland may be registered as a citizen of Barbados if that person has been ordinarily resident in Barbados for a period of at least 7 years. And Mr. Hinkson suggests that this is in fact in contradiction of the constitutional provision for 10 years. And suggests that this is something that we would need to review and rationalize. He also makes reference to certain practice that obtained in Barbados prior to 2018, which was a general policy applied to citizens from other CARICOM nations, that citizenship not be granted to many of them until many years beyond their 10 years in residence in Barbados. And that this general policy had the effect of people from other CARICOM countries being resident in Barbados for over 20 years or more, not being granted citizenship. So I read this as encouragement to regularize the discrepancy between the constitutional provision, the existing Citizenship Act, and what may be recommended in the current citizenship bill. In general, Mr. Hinkson suggests that he's in agreement with Clause 3 that proposes that anyone who's not a permanent resident is entitled to be registered as a citizen, and that any person who has been an immigrant for at least 3 years shall be entitled to be registered as a citizen. Further agrees with Clause 3.2, which proposes to provide that any person born outside of Barbados and who's a grandchild or great-grandchild of a Barbadian citizen may become a citizen of Barbados. I don't think that we've so far heard evidence to suggest any disagreement with this particular provision. Mr. Hinkson proposes an amendment to Clause 3.5 of the bill, which provides that a CARICOM national by birth, descent, or naturalization, not being a citizen by investment, their spouse and dependents who have been residing lawfully in Barbados as permanent residents for at least 180 days during the last 730 days may be registered as a citizen. Quoting from Mr. Hinkson's submission, I believe that a longer period of commitment to Barbados ought to be demonstrated in this regard in terms of lawful residence in the country. I therefore recommend that the period of lawful residence be at least 365 days out of the 730-day period instead of 180 days. Similarly, I suggest that in clause 3.6, a person who is not a CARICOM national, spouse, or dependent thereof, who is a permanent resident, ought to lawfully reside in Barbados for at least 548 days during the last 1,095 days to be eligible to be registered as a citizen, rather than the 270 days that the legislation currently proposes. End quote. Making reference to the first schedule of the bill that details categories of people entitled to be registered as citizens, Mr. Hinkson suggests that it be expanded to include former West Indies cricket captains in all formats of the game, former presidents of the Caribbean Development Bank, their spouses and dependents. Former West Indies cricket captains in all formats of the game, their spouses and dependents. Former presidents of the CDB, their spouses and dependents. Former presidents of the Caribbean Court of Justice. He doesn't mention their spouses and dependents. He finally recommends that all necessary regulations be made under clause 15, including those related to the respective fees to be paid, be drafted and available for public knowledge when the second reading of this bill is undertaken in Parliament. This importance of the regulations is one that we have heard amongst ourselves and from others, that it is almost impossible to fully assess the bill and how it will be administered unless we have sight of and are able to consider those specific regulations. We know that everybody always calls for regulations to be laid at the same time, but in this case in particular, it is really impossible for us to know how the bill will take effect and affect people without having access to those regulations or the intent. With respect to the immigration bill, Mr. Hinkson suggests that he agrees in principle with the point system and that it should be made clear that the minister's regulations on this issue relate to the allocation of points based on the education, qualification, and skills experience only, and not to any variation in the allocation of points under any of the heads. So that is my attempt to summarize the detailed submission of Mr. Hinkson. I don't suggest to review the written submission of the Bar Association today because I gather that they will come and make an oral presentation. And so the final one that we have is from Michelle Carter, submitted on the 31st of October. The submission speaks to a range of areas, including proof of citizenship, asking questions about what proof is required for common law spouses or unions other than marriage, what proof is required of those who are not Barbadian, what documents must be submitted, and so on. She suggests that in her experience, grandchildren and great-grandchildren of Barbadians often have little to no interest in Barbados. Well, I suppose in which case they will not apply for citizenship. She proposes instead that the path to citizenship be shortened, that she does not agree with automatic citizenship for great-grandchildren, but proposes that their path to citizenship be shortened compared to other immigrants, but contingent on continuous residence in Barbados for at least 2 years. There's reference made to students and diplomats, what provisions are made for non-national students. There's also a question on CARICOM citizens who have obtained their citizenship through citizenship by investment, and how they will be treated under the legislation. Reference is also made to the period of residency and integration. The consideration here is that granting citizenship to CARICOM citizens after 2 years and to non-CARICOM citizens after 3 years is far too short. If individuals, quote, if individuals are genuinely committed to settling in and contributing to Barbados, a more appropriate time frame would be a minimum of 4 years for CARICOM citizens and 6 years for non-CARICOM citizens. There's reference made to things like language proficiency requirements and questions about how people will be treated who have criminal records, the protection of jobs, revocation of citizenship and deportation, and concerns about immigration management, such as issues of mandatory private health insurance and so on. This is just to summarize the general content. The committee will deliberate in detail over all the submissions that we have received. So that closes out, unless there are any specific questions, not matters of deliberation, but specific questions on this evidence. That closes out that aspect of the agenda. We also have here with us today the minister proposing the bills, the Minister of Home Affairs and Information, Minister Abrams. We would like to hear from you. The committee has some questions. And of course, to give you the opportunity to make a presentation first of all. We'd love to have you join us a little closer. This piece. Welcome, Minister Abrams. So I propose that we give you the opportunity to make some opening remarks, perhaps give us a summary, tell us something about the intent of the legislation, and then we will have some questions for you.
Thank you very much, Chair. Is it being streamed? It is? Okay. Our immigration legislation was due for an overhaul in any event. Our immigration legislation contains some outdated concepts in it. For example, the list of prohibited persons under the existing legislation would exclude such categories as idiots, imbeciles, other feeble-minded persons, epileptics, whatnot. That's actually in the existing legislation. So that will show you how far back it was and what informed our immigration policy back then. We have been under, I won't say pressure, but in the last couple of years, especially from the diaspora, we've been receiving queries from persons who want to know how they can get Barbadian citizenship, in particular descendants of Barbadians, as Barbados has increased in international prominence. Persons are considering Barbados as a viable option in which to move to live, raise a family, educate the family, etc. So we've been dealing with those questions. If I'm being frank with you, they come up quite often in relation to persons who might be sports people, who have grandparents who are Bajans, or have a connection to Barbados and wonder if they can represent Barbados. They might not be able to make the US Olympic team, but one person I'm thinking of, she would have been like the 5th person in the 400 for US, and that person was investigating how they can represent Barbados. So we have that across the board. The questions for us in relation to the acquisition of Barbadian citizenship have been constant over the last couple of years. And we accepted that with where the government plans to go policy-wise in terms of getting a sustainable population in Barbados, that we had to look at our immigration policy as a whole, not just the citizenship aspect of it, but also the general immigration policy of Barbados in terms of persons in Barbados. A number of countries in the Caribbean and throughout the world have moved to citizenship by investment, where they effectively, you can buy a passport. That's the bottom line. You can buy citizenship. And in those instances, the residential requirement is non-existent. You literally can pay to the threshold of what the investment requirement is, and you get the citizenship. They do background checks on some of the people who are supposed to, but you have a lot of persons who, for one reason or the other, would not qualify for a visa to one country, but on their existing passport. So they seek out countries where you have a passport that pretty much has visa-free access to a number of different countries. So Barbados took a position, and Cabinet of Barbados took a position that we are not considering citizenship by investment. Investment will never be the sole determining criteria for the acquisition of Barbadian citizenship. We think it was wrong that anybody who wishes to, well, anybody can come and live here. Anybody who wishes to acquire citizenship and be called a Barbadian must never do so solely on the strength that they are more financially capable than somebody else. So let's just put it in a nutshell. The other thing we keep hearing about the population imbalance in Barbados, that we have an aging population, that in a number of years, the NASS will be unable, if we don't get more persons coming in of working age, will be unable to sustain the growing number of senior citizens or retirees in Barbados. We also accept that we have skills gaps in certain areas. A lot of our young students who get scholarships and exhibitions, when they pick their topics, we know in many instances that they're not coming back here because there's no avenue for them in what field of study that they've actually chosen. So we're educating our best and brightest for them to go somewhere else and make a contribution to somebody else. We looked at where we want to position Barbados globally. What do we want Barbados to be? We want Barbados to be a hub for innovation. We want Barbados to be a hub for tech. We want Barbados to be a hub for pharmaceuticals. We pretty much want to raise the profile of Barbados and build out Barbados in innovative developmental areas that can sustain growth for Barbados effectively in perpetuity. So to do that, we have to look at how do we keep our people here. We keep our best and brightest here by providing opportunities for them that satisfy their craving for opportunities. So if it is that you wish to be a tech innovator and the next Bill Gates, then the opportunity should be available in Barbados for you to maximize your potential and build your empire from Barbados, or use Barbados as a launching pad for your empire. So it's not just the innovation of the person, but also the creation of structures and a framework and an environment that is conducive for it. That environment requires us to build it out in Barbados, build out the opportunities in Barbados. how do we do it? Cannot do it from the ground up. We have to come in somewhere at the top to the middle to create the framework. So that requires us attracting persons who already have the proven capacity in that area to build out sectors that then provide opportunities for our young persons to study and grow into those already emerging sectors. We're looking at culture, we're looking at innovation, we're looking at tech, all those sort of things. Now, we also accept that we need to broaden our tax base. We need to broaden the persons who are contributing, who are of working age and family age, to help build back up Barbados. In the ideal world, we want the first Barbadian to be a Barbadian. So anybody coming in trying to seek Barbadian citizenship, we would let that person have a direct connection to Barbados. That you are, but I won't say child of a Barbadian, because if you're the child of a born Barbadian, then you automatically qualify as a right to citizenship by descent. But right now, if you're the child of somebody who's not born a Barbadian, who've acquired the citizenship otherwise, then you don't get it necessarily as a right. But we then look at what is a Barbadian. They're persons who have been in Barbados and living in Barbados for 50, 60 years. Then, as far as I'm concerned, as far as the government is concerned, persons who have chosen to live here, chosen to develop here, chosen to build here, chosen to contribute to our society, then those persons are as entitled as somebody else to call themselves a Barbadian. Where am I going with this? If we decided to naturally try to increase the population of Barbados, and let's say by some magic, everybody of childbearing age in Barbados conceived a child, and that child is born in 9 months, so July, probably next year, we will not see the benefit of that growth in the areas that we need it in terms of the development of Barbados, in terms of contributing to the base, contributing to NAS, contributing to the social development of Barbados for at least another 18 years. So if we attempt to do it naturally, and it was 100% successful, the first visible, tangible benefit you will start to see in 18 to 20 years, at which point we may be too far gone. So while we're encouraging, pause there. But yeah, while we're encouraging natural processes, we accept it cannot be done by natural processes alone. So that means we now have to try to attract persons in immediately who are going to build out the base that we need. And what we want those persons to look like. This is where the point system in relation to the residency requirement came in. We want to encourage certain defined characteristics, persons of a certain age, persons of a certain educational, technological skill set, capacity, persons who have something to contribute to Barbados. Those sort of things are the things that inform the point system for the acquisition of residency in Barbados. It also helps to manage the process. The point system, the points are not going to be, the points are in the schedule to the act, not in the substantive act itself. We need to be able to adjust the points based on the developmental requirements of Barbados at any given time. Whereas you may want this particular skill set in Barbados right now, the fact is when you've successfully closed that gap, there might be another skill set that you want. So those points might become less. So it is, we use in many respects, we look at the Canadian model in many respects in relation to the points. Their point system was a lot more complicated than ours. You had to get hundreds of points. And it was a lot more complicated. We are at the stage where our process needs to start now. If even we look at, let's say, construction, with all the construction going on in Barbados, there's a shortage of skilled artisans. There's a shortage of skilled carpenters, there's a shortage of skilled qualified masons, whatnot. So we look at road development in Barbados. The government is trying to increase its road repair, road building capacity, but it's the same couple contractors in Barbados have the skills to do it, and the same defined set of people. So it stymies our ability to move forward as fast as our capacity can allow. And the skill sets that we contemplate in relation to the points are not solely education. We recognize that there are different levels and different categories of skills. If you're an artist and can contribute to the artistic and cultural development of Barbados, then that skill set must be recognized. If you are a great mason, then your capacity as a mason has to be recognized in the same way that if you had a university degree. It's just the ability to contribute to Barbados in a meaningful way. So that's what informed the points-based system for the acquisition of residency. With respect to the Barbadian by descent, the other thing, we're removing classes of citizens. So right now, there's certain rights that accrue to you as a born Barbadian that don't necessarily accrue to you as a naturalized Barbadian. And it's even shown in the way some people have to take an oath, some people do not have to take an oath when you get citizenship in Barbados. So we're removing classes. Once this is passed, anybody who is a Barbadian enjoys all the rights and obligations of anybody else who is a Barbadian. So there's no first or second class citizens. We're gonna have one level, effectively, one tier of citizenship. The other thing is, if we're looking to expand our population and close the skills gap and to provide the human resources that Barbados needs to go forward, and we're saying that we want the first persons to be persons who have some connection to Barbados, then we looked at citizenship by descent right now flows from parent to child. So the question then was, why not grandparent to child? But then we also, by virtue of the inquiries that we have already gotten, we are aware that some of the requests in relation to the acquisition of citizenship or being able to come to Barbados extend past grandparent. So we're saying that as of right, a person who's up to a great grandchild of a Barbadian is entitled to get citizenship. So that covers the Barbadian connection. But who else? We want to have preferential treatment for our Caribbean or our CARICOM brothers and sisters. So in relation to the acquisition of citizenship following residency, the time frame is shorter for somebody from CARICOM than it is for somebody who's not from CARICOM. And this pretty much continues in what, in the policies, continues the policies that inform the full free movement in any event, preferential status, preferential access, preferential treatment to those who look like us and who come from a similar background to us. So that pretty much says most of it. I mean, I could talk forever on this, but it might be useful for me if, I'm sure that by now the committee would have some specific questions or policy queries that I can answer, and then based on what those are and how that flows, I guess I will ask leave at the end to do a wrap up to address anything else I think might necessarily be covered. Thank you.
Thanks, Minister. Before I pose my questions, let me open it up to members of the committee. Senator Boyce?
Thank you, Madam Chair. Thank you for your presentation, Minister. I'm going to address something initially that you didn't speak to, and it was one of our initial concerns yesterday. Let me get straight to the question. What is the need for the retention of the work and reside regime when some describe it as a virtual no man's land? You're neither fish fowl nor good red herring.
Okay, the best way to explain that is to explain how it came about. So the work and reside regime that currently exists in Barbados and has been used for a long time by successive governments has no basis in legislation. There's nothing that legislatively provides for a status of work and reside. What was acknowledged was quite often a gap was created where the equity of the situation would require some accommodation for the person who's applying. Let's use a practical one. So if I got married, let's not use myself, but I have discretion. If Miss Eli got married and came here with her husband, and while he was trying to wait to apply for status in Barbados, the fact is he's at home with no status, no right to work, no whatever. A work permit is applied for by the employer. The employer normally applies for a work permit saying that we have a job here and we have no suitable applicants in Barbados. We can't find any suitable applicants in Barbados, so we need to fill this from outside of the jurisdiction. That operates in your favor if you have a prospective job, if somebody has offered you a job, if there's a job waiting for you to slip into. If you're the person who's accompanying somebody and in that gray area pending acquisition of some status, then we had to be able to give you something. And the work and reside came about as that. The work and reside was used to plug a hole to allow the person to exist in Barbados, where the justice of the situation suggested that it was the right thing to do. So it was principally used in the lag for persons who were waiting citizenship. It was also used if somebody had applied, for example, for immigrant status or some other status, and they didn't exactly qualify. And let's say they were here on a work permit and their work permit was about to expire. If it is likely that person is somebody we would consider to be given immigration status in Barbados, you plug the gap by giving them the work and reside. It proved to be an exceedingly useful tool. As I said, it was created because a need existed for something like that. And it was used to plug a hole. So when we came to drafting the legislation for something that actually worked to create equity, it made sense then to codify it. So right now we still have work permits. We have the CARICOM access. We have the residency by points, and we have the normal citizenship. And we also have the residency converted, because anybody who, by the time this is passed, is an existing immigrant of Barbados, that person is going to be straight away converted to permanent resident, right? So outside of those that exist, where the gaps come in, then you still need to be able to allow the person to be here without fear of deportation, to be able to come and go as they please without having to be questioned at the airport every single time that they come in. So the status existed unofficially for pretty much from the time I was a lawyer. I started practicing law, which is like 30 years ago. It existed from then. It has been used by everybody, but it's never been condensed into legislation. So we took the opportunity now to just create a legislative framework for something that we're already using and we can see ourselves using in the future.
I wanted to come in as well on this point before you go on. Because the legislation as before us still does not, in my estimation, properly describe what the status is. A person who is granted leave to reside and work has access to what benefits, what rights, what responsibilities, what is the status?
The status is literally that: reside and work. You acquire no benefits past somebody who effectively is working on a work permit. The thing is, that person cannot apply for a work permit for themselves. So they can't go and look to find employment, because if somebody asks you, are you authorized to work in Barbados, you have to say no. So the work and reside, it can be under such conditions as the minister thinks fit. I think the legislation spells that one out. The minister can grant permission for the person to work in Barbados, reside in Barbados under such terms and conditions as the minister thinks fit, which is pretty much how it operates now. the person has no benefits past somebody effectively working in Barbados on a work permit.
The difficulty with this category, I mean, you describe it, Minister, in very positive terms. You describe the conditions under which that gave life to this category in very positive terms. There are many of us who have seen that the conditions that gave rise to this category were perhaps not the most positive. I have seen cases where this is, as you suggest, a bit of a holding pattern for the failure of a system to make a decision on a person's status, where a person is in Barbados, the relevant authority, the competent authority is not quite sure because perhaps of other gaps in the law, perhaps because somebody has been here for a while and you say, oh dear, well, I'm not sure what to do with this person. Perhaps because the decision is pending and has been pending for years. And then you continue to give them this kind of reside and work status, which to me, unlike what you say, Minister, is not properly codified. Because I don't think it is not a clear part of a pathway to something. So it is not clear the circumstances under which a person is awarded this, whether a person may opt to apply for this, because the way you describe it is almost as a stopgap. Well, we may have somebody who they're not quite sure how they're gonna exist here, and we give them this thing. The clause that speaks to it, I think is 5, and it really says, well, the minister can allow a person to reside or to reside and work. To me, there's no description about, I think that we have an understanding of citizenship, we have an understanding of permanent residency. I would suggest that it would be beneficial if we have a greater understanding under the legislation about what exactly, where this category fits in the overall regime. Because I do think that it does not help the predictability and the confidence of the legislation or of the regime to just have a clause that says the minister can just grant reside and work, because we still don't know under what conditions. And my fear is that it allows this category to be used, to continue to be used in the absence of a decision being made by the relevant authority, which is what we have seen over, primarily I would say, up to 2018. I thought that we would use the occasion of this reform to more clearly define what it is, the conditions under which it is granted, and it doesn't speak to that is without prejudice to any discretionary power the minister might have overall in the legislation. But that specific reside and work status, I think that there are many people living today with that status that still feel unsure about what they can and can't do and have had it for many years. Is there going to be some attempt, because I know that you said people who have been living with this immigrant status, which again is very strange language, with this immigrant status for so long, will then be moved to the permanent resident status. What about people who have had this reside and work status? Because the legislation legitimizes it without defining it.
So as it stands now, the reside and work status allows you to qualify under timelines for immigration status. So if you're here residing and working under reside and work, once you cross the threshold for immigrant status, you can get immigrant status, right? What
are you calling immigrant status? Sorry, this is just for the purposes of the conversation. What do you mean?
As it stands now, until new legislation is passed, Barbados has 3 categories of permanent immigration status. Those are immigrant status, which is the entry level, I guess, into permanence, that allows you to live, work, reside, conduct your business in Barbados. You then have to get permanent resident status. Permanent resident status has other things attached to it, and then the final one is citizenship. what we accepted is that we are probably one of the only countries in the world still with 3 layers on it, and that it is unnecessary to have immigrant status. We need to properly structure our permanent residence status to remove the, and even the name is offensive to some people, right? So we accept that. So we are doing away, once the legislation is passed, or this new legislation does away entirely with the concept of immigrant status. Anybody who's an immigrant at the time the legislation is passed is grandfathered, automatically become a permanent resident.
Right? But it seems to me that you're now replacing immigrant status with reside and work.
No, reside and work actually exists now.
No, but what I mean is, you just described to us that the intent of the legislation is to remove this category called immigrant status, right? You just described immigrant status as the right, essentially, to do what reside and work allows you to do. No?
No. Immigrant status is a status of itself. So immigrant status has certain boxes you have to take to get there. Once you acquire immigrant status, it allows you to come and go, live. It allows you to live permanently in Barbados, right?
And what is the difference from reside and work?
Reside and work was created.
No. Don't tell me what it was created. Tell me what it allows you to do.
Reside and work pretty much allows you to live and work in Barbados as well, but it is subject once again to criteria. So the chief immigration officer can actually say that you get a reside and work for 2 years, for 3 years, right? Immigrant status, the immigrant status once obtained is permanent until you move to something else.
Right. So I'm drawing your thoughts as you speak, right? So the spectrum we now have is immigrant status, 2 permanent residents, 2 citizenship.
Yes.
Right? The intent of the legislation is to remove immigrant status as an offensive category, because to say that you are an immigrant forever, it's just offense, personhood in general. But by retaining reside and work, so the intent of the legislation is to retain and legitimize reside and work, which actually creates the same status as immigrant status created, and is worse, because it is not indefinite. It is for any time that anybody might give you. And so what I'm suggesting to you is that this legislation should also move to remove anything that is so discretionary and arbitrary, and just create the conditions for permanent residence and create the conditions for citizenship. But we're still keeping this kind of vague, murky reside and work that I think you remove immigrant status, replace it with reside and work essentially, which is just as arbitrary.
I hear where you're coming from, Madam Chair. I don't necessarily entirely agree with you, because once you have to qualify for a status, then it contemplates that you may not qualify for it, or there may be an intervening period where you have not yet qualified for it. So what then do we do with the person who has not yet qualified for permanent residency? There's no immigrant status anymore, so let's pretend that's gone. What we do with the person who has not yet qualified for permanent residency, but does not fall into any other category. So the person is not, for example, a CARICOM skilled national. The person does not have a work permit. In that lag period until they can actually acquire another certain status, what do we do with them? This provides options to allow you to bridge where sometimes the straight application in law would create an injustice.
I would suggest to you that any category, any status that you are creating under the legislation requires a definition of what it entitles you to, what protections you have, what protections you don't have. That is not clear for this reside and work that you are granting. Every other category is clear. Now, again, it doesn't mean that discretion will never apply. Discretion will apply across the legislation, across the categories. But you can't say that that the legislation grants a certain status in circumstances where people do not know under what conditions. It removes the whole intent of predictability. I mean, this is just I think this is a position that others have, and it is just for your consideration. It doesn't mean that it can't be used for the purpose you've just described. It just means that it has to be defined, and it has to have a home somewhere, because otherwise it does what you are suggesting that immigrant status did, and the reason that you were looking to remove it.
Madam Chair, I hear you loud and clear. Let me tell you why I'm glad for this process. Because following this process, we will review carefully your report. We will liaise with the CPC. We will look at what the intention of the legislation was, where amendments need to be made to give proper effect to the considered opinion of the report, as well as the policy of the government. Then those legislative changes will be made. So nothing here is fixed in stone. We drafted the legislation. We are aware that there are certain parts that will attract some discussion. And it is with the best will in the world, ex-people in the cabinet can sit down and look at something from the position of those in that room. But there may be a position that we did not contemplate. Even the drafters, the reason legislation gets amended is that you draft the best possible legislation, but you cannot provide for every possible contingency. And some things you draft it, and the application of the legislation itself throws up some inadequacies, and you have to come back and backfill those. I guess this process allows us to hear from everybody who has a contribution to make, so that the final piece of legislation that goes back before the House for the continuation debate, or in the event we have to pull this one and replace it, that has benefited from as many inputs and as wide an input base as we can, because this is legislation that pretty much applies to all of Barbados. Every Barbadian should be concerned and have an opinion on what your immigration, what you want Barbadians to look like. How do you want people to get Barbadian citizenship? What are your cares and concerns that you want us to factor in doing it? So I hear you loud and clear. I have made a note. If I'm being frank with you, one thing I expected, because we had to settle, for example, for the citizenship by descent, we had to settle on what that looked like and how far back we went. We also had to look at the ability of somebody past a certain point to prove their lineage, their descent from a Barbadian. So those are the things that we factored into. I knew. When I came in, I heard you reading through some notes, and I knew that there was going to be a discussion as to whether some wanted to stay exactly as it is, that only if you are the child of a Barbadian you can get Barbadian citizenship. Some wanted a grandparent, some wanted a great-grandparent. So we did the best we could on the information that we had. But it'd be interesting to hear the final position of the committee in relation to that. So, as I said, there are things that we knew. I mean, immigration is as fundamental to a country as anything else, and particularly with Barbados, based on the policy objective we've outlined and the reality of our situation in the country, largely yielded by research conducted by you, Madam Chair. We know we have to get from here to here. And we know we have to do it quickly, and we know we have to do it safely. But what does quickly and safely look like, and what are the concerns of Barbadians? Because at the end of the day, the aim is for as many Bajans as possible to be comfortable with this legislation and feel that it represents their view as well as the view of the government. So I hear you on the work and reside.
Sorry, I just want to check.
Just to make a point, with residing work, to my mind, is best compared to work permit. Because with the work permit, you are given a specific job that you can work in. As opposed to resigning work, you're given that status so you can do anything and still resign.
So to answer to the Clerk of Parliament, all the persons who get a reside and work, if they had a job offer and a valid application, work permit application, would not need reside and work. But once again, as I said, the work permit application is done by the employer for a job, not necessarily specific to the person. That just happens to be the person who has answered the call and they think is qualified to do it. This allows, if we had a work permit at large, that I come to Barbados and I want to be here and I want to work, I don't know where I want to work. I know I might want to work for her, but I don't know if she's offering a job, right? But I can apply for permission to be in Barbados to work on my own behalf. So like a work permit at large, that's pretty much what this is. So I'm glad that the clerk pointed that out.
That's fine, but we need to say what it is.
No.
The legislation has to say what it is. The legislation has to say under what conditions a person can apply. It might be that you may be trying to keep it in your back pocket for such an occasion as ... I'm not asking you to answer me.
I hear you loud and clear, Madam Chair. We will factor the considered report of this committee into what this regime finally looks like.
Thank you, Madam Chair. I'm going to jump around here just a little bit. Explain to me the point system with particular focus on the need to ascribe or the ability to ascribe to dependents the points of the applicant.
Okay, so using Canada as the example, when we draft legislation, we don't necessarily start with a blank sheet. You usually have in your mind some model legislation that you're patterning yourself on. Quite often that's where you actually get the ideas for the amendments from, that somebody else did it differently, and this is a good idea, we should probably try to do this. So, with respect to the dependents, if you have somebody who is super qualified, right, and that person has a spouse or dependent that is not as qualified, so let's say we're trying to get to 10 points, and that person, by virtue of the criteria, can by themselves accumulate 30 points. Then Canada had a position that the excess points can be applied to a dependent, but it can only be done once. So we thought that, because if the spouse is coming with the person, so you are getting residency by virtue of the points that you've accumulated, and your spouse is coming, and your spouse of themselves can't accumulate the points for residency, then the spouse on the back foot. So why should you not be able to, if you're coming as a family, if there's a link of dependence between the applicant and the person they're trying to give the points to, then you share income, you share resources, you can share points. I don't know if I answered your question, Senator.
You did, Minister. I am not convinced, but you did. Madam Chair, I have a question around the submissions, the particular submissions. I don't know if you want to go there and
I just want to come back to the Senator Boyce is preparing the and then I just come into the back a little bit. I just want to come back to the point system, because you said, you made reference, Minister, to something that I actually had in my notes, which refers to the Canadian system. I wonder whether our proposed point system may not be oversimplified. And I'll tell, and again, if the regulations are meant to go into more detail on the actual allocation of points and how that breaks down, that might be helpful for us to consider. But I think one of the reasons that the point system in places like Canada has these various ratings, has these two systems, which is one for the public service and one for the this comprehensive ranking system that I'm sure you've spent a lot of time with in coming up with this legislation. One of the reasons that is, you suggest that it's complex. It's not really that complex, but it tries.
Ours not, I mean, Canadian system.
Right.
Okay.
It's not, the Canadian system is not really that complex, but I think what it tries to do is it tries to account for and weight in a more nuanced and perhaps more sophisticated way certain attributes like work experience, language, education, and so on. And I think the reason they try to do that is that a simple assessment of certificates or degrees or age, well, age is age. You can't break that down anymore, right? And financial assets is for the purposes of moving and living, not all, it is often too simple, too simplified. Like there are other attributes and kinds of things that need to be understood about the person moving. And so I wonder if we have, in trying to be simple, and understand why we want to move quickly, but I wonder whether we are not omitting some of the important things that should be considered. Because when we have financial assets, sorry, I'm not quoting it directly, skill level and age, it then becomes perhaps a little easy to be able to predict, well, this is who we're going to get, really, right? And who we are going to get is perhaps not specifically the type of worker that we want. Not someone with the range of attributes that we want, because we aren't actually assessing the other kinds of attributes that other systems are assessing. So one, the regulations that you contemplate, are there going to be more nuanced? So for example, you have skills, but are you looking at years of experience in particular things? I'm assuming the regulations are going to speak to that, and maybe you can tell us a little bit more about that.
So what I can tell you is that the points are not fixed in stone. As I said at the beginning, the points will be subject to change depending on the developmental needs of Barbados. So they might be simple now because we need boots on the ground now. Let me use an example. During COVID, we threw open our doors with the Welcome Stamp program. We got a couple thousand people coming to Barbados from the Welcome Stamp program. The only real requirement for the Welcome Stamp program was that you were capable of maintaining yourself and that you did not work in Barbados. So you earned your money outside of Barbados, but you can be a nomad. So if your job allowed you to work from remotely, wherever your job was based, you can come here and you can work. And once you were not taking a job from a Barbadian, that was the intention. The Welcome Stamp program, let's just say there's so many people who came here initially on Welcome Stamp who now apply for status, or who bought property, or who invested, who become Bajans effectively, right? But the only criteria at that point in time was that you didn't work in Barbados and take up a job that was meant for Barbadian. Now, we benefited from a couple thousand people coming here on what was an easy access route into Barbados. I mean, we did our background checks, so anybody who had, I can't speak too much about that, but we did solid background checks, and anybody on which there was a flag or it was denied. So if you had something sinister in your background, or suspicious, or under investigation, or whatnot, then we denied you, right? But once you didn't have that, pretty much it was come and have an extended vacation in Barbados. You can work from here. You can live here, you can whatever. We welcome you to Barbados. That program was very successful in giving us a bump that we needed at the point in time. The requirements for entry into the program were not overly onerous. You just had to be able to sustain yourself here. So we looked at that as a means of getting the bump that we needed. It may be that in 5 years, the point system becomes a lot more detailed. It may be that in 5 years, you get less points for certain things and you have to tick off many more boxes. But we actually have to start somewhere and kickstart the process. And that was what informed those points. But once again, I am interested to see what suggestions come in relation to points, points allocation and categories of acquiring points out of this, because as I say, it's not fixed in stone. Persons have asked me already, if I'm being frank with you, I'm always frank with you, by the way, but people have asked me, why 10 points and not 15? If you have 15, it allows you to create more categories. So I've already had those sort of inquiries. I'm curious, there's certain things in particular I'm looking or expecting to see coming out of your report, and one of those is in relation to the points as well. We made a decision, what would give us the initial impetus, bearing in mind that we need to create a framework that we can come back and amend those, adjust them, wipe out some entirely, or add in some. So that was the initial framework that we came up with to start the process, right? As I said, it's not fixed in stone, and I do believe that coming out of this, especially from what you're asking me, I do believe I can see some of the recommendations already that I believe you're going to make. And as I said, we're trying to give the most comprehensive piece of legislation possible that as many Barbadians as possible can be comfortable with. So I await your input.
Senator Boyce.
Thanks. Several of the submissions appear to be concerned about the level of ministerial discretion in the legislation. I want to give you the opportunity to respond to that as a claim, and to perhaps tell the committee why those provisions are necessary.
In most forms of immigration legislation, there's a lot of discretion on the ultimate authority, whoever that authority figure is, to make certain decisions. Immigration is one of those things that is generally not questioned, because a country has the right to say no to anybody. I have to be careful. So immigration is a part of our border defenses, right? And is also a national security institution. I have had as a minister to refuse persons who, on the face of it, look like people we want to come to Barbados. But they're then flagged for whatever reason. And it is a reason that is shared within an exceedingly limited group of persons. And you don't even tell the person, they will get a denial. And they will never know, well, quite frankly, they very likely may have some idea what the reason is, but you don't, if we are forced to put into writing or give reasons for certain things, it compromises national security. So if you look at immigration legislation across the board, there tends to be a wide discretion, in particular a wide discretion for refusal. Some people go to the US, land in the US, reach the kiosk, some people with visas, and then can't come in. And you are turned around and put on a plane, you have no idea where you cannot come. But each country, for the purpose of national security and protecting its border and its citizens, has the right of refusal. And you will often see it without the reason, without having to give reasons. If for some reason, Senator Boyce, I have to tell you that we use FBI Interpol Protocol 6.1b and discovered X, Y, and Z, but we've already compromised our intelligence assets in relation to it. So that is why you often see a wide ministerial discretion. But having said that, if you look at the ministerial discretion in relation to fundamental things, for example, citizenship, the only real discretion you have is in relation to a minor child in terms of citizenship, right? As the minister, there's not a lot of wide unexplained discretion in there. So for certain heavily regulated aspects where the boxes have to be ticked, this requires exactly these qualifications, then the discretion doesn't really play. But for the other things, especially in relation to entry and access and prohibited persons and whatnot, that discretion must be able to exist, and it must be able to exist without given reasons.
Can I take this a bit further? Related to that, Minister, there are also a few calls for institutional structures, arrangements that almost replace or share the responsibility of making some of these decisions. I'd like you to respond specifically to that. There are calls for appeals tribunals and other kinds of mechanisms. Do you see scope for that in the legislation, and particularly with respect, not to immigration decisions, but with respect to citizenship, the pathway from permanent residency to citizenship?
It's difficult for me to answer that unless I have specific things to answer in relation to. Let me use an example. In relation to the appeals tribunal, right now, under the existing legislation, appeal tribunal exists. And it allows an appeal to be heard effectively from the decision of the minister. And the minister has overriding discretion. And so the tribunal exists now in law, and it is presided over by a minister, but not the Minister of Immigration. It's almost a little bit of a nonsense that a minister not over immigration should be able to overrule the decision of a Minister of Immigration when that minister may not even have access to the information the Minister of Immigration has. So let me call names. As the Minister for Home Affairs, I sit on the National Security Council, and that's a very, very limited scope council where pretty much you hear all the things that are necessary to run a country, but that the average person and even other members of cabinet will never hear. If I make a decision based on those considerations and somebody appeals the decision that you said no to my citizenship, or you said no to my residency, or you ordered a deportation order against me and I wish to have it reconsidered, then we have to play very carefully with giving the person access to some path of natural justice, but also protecting the fact that sometimes you actually just can't say what the reasons are. So it's a very, very fine line that we tread in relation to it. It's a fine line that we tread in relation to it. So that's where the difficulty comes in terms of immigration. It's easy to do tribunals for almost anything else. But because of the national security concerns and the information which may inform a decision of the immigration department or of the minister, it is difficult to have that scrutinized or adjudicated on by somebody who does not have the same access as the person who made the decision.
Is it contemplated then that the current appeals tribunal will no longer exist under the new legislation?
It has been removed.
Senator Boyce, anything else from you? Any other questions for the minister?
Just very quick one, Chair. Monitoring, I would expect that you would want to be able to satisfy at the end of the day that this new piece of legislation is achieving the objectives set out. Now, one among them, of course, is to increase the population. So I'm just wondering if there's any contemplation that, there's going to be a monitoring system that will require, for example, annual reports from the Immigration Department or the Ministry or something like that, so that it gives you an additional opportunities to be able to assess how this legislation is progressing in terms of meeting the objectives set up.
All right, so in terms of the monitoring, as it stands now, the immigration provides statistics to different government departments based on their need. So we provide statistics on work permits, on citizenship, whatnot. We work very closely as well with the Ministry of Labor. The relationship with the Ministry of Labor has deepened even further because of the full free movement regime. So we're working closely with them to track the persons who participate in full free movement and to see from their side who's actually taken it up and registered and whatnot. So we will keep detailed records as we do know of all persons applying for status. We keep very detailed records of how many people got work permits, how many people got work permits in what categories, how many people who qualify for immigrant status, residency, citizenship, who was deported, whatnot. So we keep all of those. So it is not proposed that the immigration itself is going to monitor the efficacy of this. I think that would probably more come from labor or social services or persons who have the direct responsibility for like the NASS and whatnot. But I will tell you that the information is well kept and well available, that anybody who needs it can call for it, get it, and make an informed decision. But in terms of immigration itself, monitoring the population growth in Barbados, no, that's not contemplated.
No, I think that is obviously something for the statistical department perhaps to be doing. I did not know, but I just want to know that the system is such that it will provide that kind of data and information which will allow the analysis to be done.
I understand and I expect that will be done.
Thank you. Minister, we had quite a bit of conversation this week on the question of deportation and the mechanism for that. Deportation orders, how they're made, and the period that is allowable for a person who receives a deportation order to ask essentially for a stay, at which time a fee is payable of $3,000, and then the process is triggered. A non-refundable fee of members reminding me.
There's no fee payable at the moment, you mean in the new legislation?
Yes.
Okay, all right, good. So, deportation is a last resort. Deportation is not entered into lately. At the end of the day, is in the discretion of the minister. What happens normally with a deportation, if somebody does something that's offensive and it is investigated, a report is produced by the investigating officer, and it is then sent on to the supervisor and then on to the chief immigration officer. And at each stage, the person who's next in line will make their comment. They don't always agree, right? But they'll make the comment. It then goes to the chief immigration officer, who looks at all the evidence there and then makes their final comment. It then comes to me because I'm the person who has to sign the order. I will tell you that it used to be a case of every person who got a criminal conviction in Barbados or who ended up before the court, they got deported. It used to be as simple as that. Everybody, if you had a spliff and you got convicted, they're looking to send you out. If you had a fight with your girlfriend, and even if you didn't get convicted, but they discover you overstayed by a day, they'll let send you out. That is not conducive to what we're trying to achieve now going forward. I mean, even down to the persons who've been in Barbados for like 30 years, and they get held in a fight somewhere, and they get a conviction for disorderly conduct or something. Next thing you're looking to deport the person. Policy-wise, we've adjusted that recently. And right now we save deportation from persons who anybody looking at your file will say this person really needs to go, right? Once persons have been asked to leave Barbados, it used to be discretionary based on when the person applied to come back, that you look at the nature of the offense. If it was somebody who had, let's say, imported 10 pounds of cocaine or something, then you wouldn't consider them in 5 years. But if they were clean and the record clean for 15 years and they now turned their life around and there's evidence of that, then you would say, all right, we can look at lifting this deportation order. So there's no fixed amount of time that a person has to spend in the country. We then got a situation where in 2008 there was a mass deportation of persons from Barbados. And something as simple as the person had 5 back-to-back work permits, and the last work permit was out 2 months ago, and they happened to do a sweep, capture that person doing a sweep through Fairchild Street, and you deport the person who's been here for a while because the work permit is now out. So we have had a number of those kind of persons with like the minimal reason overstaying, who were deported in that period, who have applied to come back in. We pretty much, if there was nothing negative against you, the general thing is we revoke the deportation order and allow people to come back in. But on the other side of the scale, we have had persons who have been convicted in Barbados. They serve a prison sentence and they get deported out. And then within a year, they're planning to come back for the deportation order to be lifted. And we had so many of those that it actually became a problem. We had people literally being deported, landing in the country, and in months, they're turning around applying. So the nuisance applications, right, got to a point where we had to, you shouldn't make it frivolously. There had to be some consequence for it. The other thing is there's generally a cost attached to deportations. So where persons have infringed on the laws of Barbados, or we want them to leave, if they have the capacity and they haven't been convicted, in many instances, we let a person buy their own ticket and they leave. That person is looked at slightly different from somebody who's deported. When the deportation order comes, pretty much the government of Barbados stands the expenses for the most part of deporting the person. So there's a cost attached. So equally, if you have been legitimately deported from a country and you wish to come back, there must be some measure of restitution being made to allow your application to be considered. So that's what actually informed that.
All right, I'm trying to find the clause because our reading of this relates to the minute of receiving, so the person is here. This is my reading of it. I'm looking for clause 23. Thank you. A deportee may, within 24 hours after he is served with the order. So this is presuming what? That the person has been deported?
No, you get served with the order.
And you're still here?
Yes, you must receive the same order before you actually deport.
Right, so I'm not talking then about some of these situations you just described where a person has been deported, they reapply within a year. I'm talking about receiving the order, and they have, the provision here allows them to make application in writing to the minister for revocation of the order. Where a deportee makes an application referred to in subsection 1, the deportee shall pay a fee of $3,000, which is not refundable. So it's saying to me, this is saying, I get the order, you say I have to leave. I'm asking you to revoke the order, and I have to pay $3,000 at that time, right? So that's what I'm describing. Now, the scenarios that some of us discussed, and I noticed that you went directly to criminal convictions. But under the law, really you can be deported for overstaying, right? You can be deported for overstaying for 20 years, right? And in such a scenario, you may have children, you may have other dependents. I hear you talk about what normally obtains. And the thing about legislation, as we are seeing in several jurisdictions around the world, is that if it is not written for such a time as some kind of, I shouldn't say, somebody who is not as credible as...
I understand.
Right. If it is not written to protect from that kind of behavior, then, I mean, what is it worth? So what we questioned was how high the fee is, just to say, well, hold on a minute. And really what's the justification for that, and whether there's scope to revisit that fee such that, you know, if I'm here with a few children and my grandmother that I'm taking care of, that you can't pick me up and cause me to leave. I understand what your intent might be, but it may not always be the minister.
So I take that point, and this is one of the things that I expected to arise. Now, what I will tell you is that we have not been deporting persons in recent times for simply overstaying. We encourage the persons to regularize, right? It would have to be something else that led to that. So people have been coming in all now to the immigration department who've been here, who overstayed, whose record is clean, and asking to regularize, and we've been facilitated. Because if the policy is to bring persons in to Barbados, then where are we trying to send you out if you actually done nothing? And the bulk of the people who have overstayed are from the Caribbean, for one, and they're in jobs. They're in jobs, have been in jobs well, and as you said, have connections. Some have even, quite frankly, bought property in Barbados. So the intention is not to deport those persons. Anytime I see a deportation order, no, it is that they may tack on the fact that you've overstayed, but that's not going to be the sole reason. It's going to be that something else led to you being investigated, started the process rolling, and they just start that one on as well. But I take your point entirely, and as I said, Madam Chair, this is one, there are people who feel that this fee should be more. There's some Barbadians who believe that Barbados is for Barbadians, right? And nobody has a right to be here other than a Barbadian. I feel this fee should be more, but I also accept what you're saying, that there's some who feel that the justice of the situation should warrant that the person, because this may take it out of the range of persons who don't have resources to make the immediate payment of the $3,000. So I hear you on that, and I guess we can revisit that one.
So there were some definition issues throughout the legislation that I don't think that we have to go through in this forum, except for the one that relates to the definition of disability. Under 6.1.3, I believe it may have been. There are several pieces of legislation that reference persons with people living with disabilities. And what we found, as you know, over the years is that those pieces of legislation define disability in various ways and had various categories for all kinds of reasons. And so one of the things that we are suggesting may be a bit of a gap in this legislation is that we are not clear how, and 6.1.3.6.3. This is where paper comes in handy, see? And this is of the immigration bill now.
Mm-hmm. So if, I think I know where you're going there,
Yeah.
right?
Yeah.
So what happens here is where you have a specific piece of legislation like this that makes reference to something capable or worthy of being defined, it might not necessarily be prudent to define it here. So a person who's under disability for the purpose of this legislation would be wherever the actual definition, official definition of a person with a disability is found in our laws. So we won't define every single term.
Sure. However, you will be aware that we've had challenges in the administration of certain pieces of legislation. For example, there are, and Senator Boyce made the point that we really need to say, is this definition going to be the definition that is established in the Rights of Persons with Disabilities legislation, in which case I think that should be explicit, because for example, we've had cases, and the most recent example may have been national insurance, and what are the categories of disability that qualify for a benefit. Now, for years, national insurance was laboring under this kind of old and outdated definition, and disability was referenced in their legislation, but the categories did not match the intent of the law. So I think that we have to be very clear on this. You know, if we are saying that all legislation that references disability is using a particular definition, then we need to say that. But I don't think we're at that point yet, and I just feel, Senator Boyce?
What I can say, I take the point, what I can say is, Justice Moore, in our amendment to this, we can define dependent who's under disability as defined in X legislation. We can cover that relatively easily. You need to press it.
Disability in this case would be a legal disability, not a physical. It means that the person is unable to, in law, either by age, that's a disability, or he is otherwise unable to sign for himself or something.
What we can do
It's not a physical disability.
All right, what we can do is specify it to cover that off.
These things must be read in the context in which they're used. Well, disability in this case is a legal disability and not a physical disability. If you want it defined in that terms.
Yes, we do.
Yeah.
Senator Boyce?
Given that discussion, perhaps I intervene only to make the point that it was a very recent administration that repealed the section of the Immigration Act that barred entry into Barbados on the basis of various types of disability. And I think in the contemplation of this new legislation, let us be clear that we're not in any way unwittingly and inadvertently replicating any of those restrictions and discriminations, yeah? But I do take Justice Moore's point.
Senator Boyce, allow me to assure you and this committee of one thing. The most offensive clause in the last legislation was the list of prohibited persons. I first was confronted with that as a lawyer. I was embarrassed that it remained there. It was also on the immigration form because it was in the legislation. I am pleased, like you cannot possibly believe, to be able to strike that and all references to that from our landscape. It is backward, it is insulting, it is offensive to persons who are vulnerable and who have to live with a disability. And I cannot believe it survived that long. But so I hear you loud and clear as well, Senator Boyce, and anything we can do to try to clarify that, we will do, because any specter of that must be removed from out the legislative landscape of Barbados, and for certain from this act.
Minister, there are those who suggest that the current legislation should speak expressly to the welcome stamp visa, and to those who are currently here under that provision. Some of them have been asking expressly, what is the pathway, whether it is a simple residence, existing residence, time already in Barbados, that then allows us to apply for permanent residence. Do you contemplate this bill, or is there scope for the bill to make special reference to the people who are here on the welcome stamp, or is there some provision that already exists in the bill that would encompass those people?
So when we were drafting the point system, when we were trying to figure out what's the best way to deal with the point system, to allocate points, pretty much every person on the welcome stamp would qualify on the points basis. But do we specifically have something addressing the welcome stampers? No, we do not. Is it something that I wouldn't want to limit it to the welcome stampers. If you look at the welcome stampers as a category, if we go back at this, then I prefer it to be not category specific, but to contemplate the category in the drafting, if you understand where I'm coming from. So I wouldn't want to say welcome stampers, then somebody else say, well, why not X or why not Y? If we have to look at that, so I understand.
Or perhaps part of the point system.
Mm-hmm. Okay, fair enough.
There's also some dissonance, it seems, between the Constitution providing that a person who's been ordinarily resident in Barbados for at least 10 years, immediately preceding their application, having the right to be registered as a citizen of Barbados, and the existing Citizenship Act making reference to at least 7 years. And then there's a different threshold again for the new legislation. Now, some of the feedback, with that as the context, some of the feedback that we've gotten and some of the discussion that we've had relates to the threshold for residence, which is separate for CARICOM nationals and for non-CARICOM nationals. For non-CARICOM is 270 out of...
You mean citizenship?
Citizenship. Well, yes, for citizenship.
Okay.
So you are a resident for 270 out of 1,095 days. So that is 9 months in 3 years. So there's that new provision in the new legislation. There's the old legislation that of 7 years, of which at least 5 years in the aggregate has had to be spent in Barbados. And then this threshold is significantly lower.
So ultimately, anybody who is seeking residency in Barbados is ultimately seeking citizenship, unless there's a particular reason they don't want to do it. So there's some persons who have residency in Barbados, they don't want citizenship because, for example, they might hold a Dutch passport, and the Dutch don't allow you to have dual nationality. So, but the average person who goes through the steps of getting residency is looking ultimately to become a citizen of the country. Now, we are trying to fast track the regularizing of the immigration status in Barbados in terms of the appropriate population, the appropriate skill sets, whatnot. We have to be careful in not making it, I'm trying to be very careful what I say here. We have to be aware that there are many other options out there available for persons who are looking to relocate and reside somewhere else. Almost every country in the world, a lot of European countries, the US is doing it as well, almost every country in the world is having some sort of population grab. They're trying to attract people in particular, persons with resources, whether that in terms of monetary or skills or whatnot, but they're offering incentive programs, even the US is doing it, for persons to reside in their country. So in what we were doing, we looked at the most competitive residency to citizenship programs in the world. And we said, how can we compete on this level without selling our passport? Right? How can we do it but make sure persons have some linkage to Barbados? So the concept of the citizenship by investment, the concept of the donation to get a passport was one that we red flagged. We are not going there. Script out. That's not being contemplated at all. But outside of that, how can we make it as attractive and as simple as possible for persons who ultimately want to reside here? So the contemplations that we had persons who have who have a house in Barbados and who are here 3 to 4 months every year and have been here for 30 years, coming to Barbados for 30 years, but they can't qualify for citizenship. They can never qualify for citizenship because the time is, they don't accumulate enough time back to back to do it. We have persons who wish to have a property in Barbados and they wish to set up business in Barbados, but they have properties and businesses elsewhere. So they can't live in Barbados for 5 years in terms of the actual residency, normal residency requirement, which is half a year. They need flexibility to be able to go and service what else it is that they have to service. So we look at, okay, what is the minimum time commitment we require from somebody who is transitioning from residency to citizenship? And that time requirement was 3 months a year for 2 years if you're CARICOM national, or 3 months a year for 3 years if you are non-CARICOM. Why? What are we trying ultimately to protect? We're trying to protect the integrity of Barbadian citizenship, we're trying to protect our way of life, and we're trying to protect the security of our country. The question was raised as well, if somebody who is a citizen by investment in another CARICOM country, so they're then traveling under a CARICOM passport, if that person comes to Barbados, qualifies under the point system to be a resident pretty much instantaneously, then what happens when that person applies for citizenship of Barbados? Now, I start again by the fact that you qualify in terms of time does not mean you can get citizenship, because we have the right to deny anybody citizenship. So if one of the things we do with every citizenship application is we do the background checks. We run it through a number of databases. And if you are flagged as somebody who, for want of a better term, we don't want in Barbados, then you don't get it. So we look at what is the we want the person to show a time commitment to Barbados. So if you're a non-CARICOM, we want you to show a commitment to Barbados for at least 3 years. Right, so although it's 9 months, if even you do 9 months in your first year, you still can't apply until the 3 years have passed. But we also then look at what is sufficient time for us to satisfy ourselves, having checked everything, that this person is not a risk to Barbados, or this person does not offend the policy of what it is that we're trying to do, the policy considerations. And that time frame was 90 days if you're non-CARICOM. 3 years if you're non-CARICOM, and 2 years if you're CARICOM. We have satisfied ourselves that we can fully check out the person, get everything we need to know, and decide whether we want you as a Bajan or not. So does it make sense to extend to 7 years? If we did, there's nobody now who is drafting immigration legislation that is keeping the time frames as to what they were or lengthening them. Every single country, and Judge Moore would tell you, we've checked, every single country that is now pushing forward immigration legislation is shortening the time frames to citizenship. They're making it more accessible. They're trying to get a certain class, let's not use the word class, they're trying to get, they have in their mind what they want their citizen to look like? What skill sets, what contribution, what is that person going to do for the development of your country? And if you're somebody who is a high chance of contributing to national development, then it should be made as simple as possible for you once we cover our bases from our end in protecting our citizenship, protecting our passport. So just for the record, if somebody comes who is a citizen by investment in one of the CARICOM countries and they come here and they get a residency and they apply for citizenship in Barbados, if our checks do not reveal anything derogatory or negative with that person, then they'll be processed. If our checks do reveal something suspicious, they're under investigation for X, Y, or Z, or they're flagged by Interpol or whoever else, right, then they will not get it. So it is not that you've lasted out the time frame for transition for residency to citizenship does not mean you have a right. Nobody has a right to citizenship in Barbados, save and except you were born here.
Before you came, Minister, we had some conversations around the context for this legislation, which you also referenced in your opening, which is the population policy, and the fact that this legislation, it really sits on the bed of that policy. It is not meant to stand on its own and to say this cures all of the issues of sustainable population growth and education and housing and land and everything that government has to do. In your response just now, you made reference to doing background checks, suggesting really that the main consideration that people might have with respect to the time that to which we're restricting people to qualify from permanent residence to citizenship is a question of whether they may be criminal elements. There are people who have other concerns that have to do with this notion of carrying capacity, well, capacity of the state, to be able to make room for everyone. The population policy did a lot of that forecasting, and the population policy with respect to housing and other things was able to say definitively, look, Barbados can, in a sustainable way, accommodate this amount of housing and so on. However, there are considerations, I believe, that have to do simply with the geographical size. You sit in Parliament and in Cabinet, and you are aware of the conversation that relates to land ownership, home ownership, and so on. You are aware of the conversation that relates to the capacity of others to buy and own assets, own businesses, in principle take over large swaths of land in the country and be able to develop them. Is there policy contemplated, bearing in mind that there is a broader policy framework for this, is there policy contemplated that will concurrently look at some of these issues of land and property ownership, the balance of ownership among Barbadians and others? Can you speak in any way to any kind of affirmative policy that says, look, just like other jurisdictions have done, we are aware that many of the people who are likely to come under this legislation have the wherewithal to own and acquire, and own. Is there any kind of affirmative policy that the government is contemplating to be able to secure land or assets for groups of people who may otherwise be disenfranchised going into the future?
Madam Chair, you have me at a serious disadvantage. I did not come here contemplating discussing that, but allow me to say this. As it stands now, we have, unlike many of our Caribbean neighbors, we have no alien landholding legislation. So we have nothing that restricts the purchase by anybody of anything in Barbados. So as it stands now, anybody, a visitor comes here and they see a plantation they want to buy, they can go and buy it as a visitor once they get the central bank permission, and that has to do mainly with the foreign exchange and less to do with whether you're alien or not. So this does not affect that. This does not move the needle either way in any direction where that is concerned, because as it stands now, it might be even better for us, quite frankly, if the persons who are buying property in Barbados become citizens of Barbados. But as it stands now, anybody can come and do what you've outlined just now, citizen or not. So this does not take us, this does not affect that scenario at all. I am not aware that there are advanced discussions to regulate who can or cannot purchase in Barbados, or in terms of positive rebalancing. And that's probably the best I can say. But I will tell you that the immigration legislation as contemplated and as drafted does not affect that scenario that you just outlined at all.
I think perhaps the conversations that government has from time to time, or Parliament has from time to time, about the approach to access to land and resources, for example, outright sale versus a 99-year lease, and these kinds of discussions might be material to that conversation. Because, again, the population policy does talk about a balance of enfranchisement. And I think one of the things that people are interested to hear, and I say this as a general point to the government, not necessarily with respect to this legislation, is that often when we bring new legislation, we are aware that we're going to have to make concurrent investments in other kinds of policies and different aspects of people's well-being. So I leave that on the table as a general observation, so that when we have the discussion, that we're having a full discussion so that people can understand, look, everything cannot be in one piece of legislation, but certainly there are other conversations and other policy improvements and reforms going on that might address some of these issues. But I am minded to repeat some of the findings of the population research and the population policy, which does essentially say that once we continue to invest in these areas, that things like housing and education and access thereto are not in any way delimited or constrained by a positive immigration policy. Any other questions before the minister wraps up?
Sorry. One quick question as it relates to residents from the other territories who have received their citizenship via the CIP. Would they be treated in any different way than other CARICOM nationals, for example? That's one part of the question.
So that was a major thing that came up. Once again, as I said, one of the ultimate concerns was we don't want to compromise the strength of our citizenship or the strength of our passport. So we don't want to put ourselves in a position where we are scrutinized or blacklisted in the same way that some of our other brothers and sisters in the Caribbean have been, especially that we've just now come off of some other lists. So, no, they're not going to be treated any differently in terms of the acquisition of residency. The residency is by the point system. Once you qualify for residency, then you get your residency. The time frames and the differential in time frame comes in terms of the moving from citizenship, moving from residency to citizenship. So if you have a CARICOM passport issued by, let's call it country Dominica, which has a citizenship and investment program, Dominica has issued you with a passport. You are a Dominican national. It's not for us to look behind that. So you can come to Barbados. your time frame will be shorter than somebody who did not have that Dominican passport. But the 2 years still allows us, I mean, the background checks we have will say how you got your citizenship. So we will notice a citizenship by investment person, and we will do our due diligence on you accordingly. If something negative is turned up on you that makes you not the ideal person for citizenship in Barbados, you will not get it. But equally, if something if we're looking at anybody, we're looking at a born Dominican national. I'm only using Dominica because it has both roots of citizenship. Mm-hmm. If we're looking at a born Dominican national, and something is flagged that you were trafficking in children or something that makes you undesirable, then you're still not going to get it. So we feel that 2 years is well sufficient time for us to properly conduct investigation of anybody who wants to be a citizen of Barbados. Why 2 for CARICOM and 3 for everybody else is because we accept that CARICOM has to have a preferential status in our contemplation, and quite frankly, we didn't want to do 1 and 2, so we went 2 and 3. Okay. Right, but if you come here with a same way, if the free movement, full free movement, if you come here with a CARICOM passport, we're not looking behind that passport. Your country issued that passport to you. We're not looking behind that passport, but that equally does not mean that if we have to accord you a status of our own, that we're not going to investigate you fully. We investigate fully every single person who applies for immigration status in Barbados. I can't go too far into the background checks that we do, but they're like double and triple checks. Right? A lot of people who don't get the status that they expect and are left wondering is because something was flagged in there. If it is something that we think is worthy, or we think they give you the opportunity to clarify, then we will tell you, look, this came up. What is this? Did you get an expungement on this? If it's something small that you borderline, but if there's a major red flag on you, then you just get the no.
Okay, thank you, Minister. I think because some persons would see it as a way of acquiring Barbadian citizenship or Barbados passport, maybe on the first hop, as opposed to full. I mean, using cricket analogy.
All right, so once again, we are aware that our passport gives visa access, visa-free access to a number of territories, in the same way that other passports do not. What that is based on is the strength of our economy, developmental issues, and also the security surrounding our immigration status. The verification processes that we have, we are satisfied that this does not run afoul of those and are not going to jeopardize our passport. If you are a citizen by investment, you still have to wait the 2 years that the normal citizen has to wait, at which point in time we investigate you fully. Right? Our structure is designed, and even the judge can tell you, when we did this at certain key points, we were like, how does this rank? We then pull other countries to look at what their legislation said. We also looked at the criteria for evaluating passports, the criteria for this, the criteria for that. And only if we were certain that it did not compromise this, did that clause go through. So it is, people think of the passport just in terms of time. How long does somebody take to get a passport? It's not simply that. There are a number of criteria that go towards the evaluation of the passport for its ranking, right? And we don't intend to compromise any of those by this.
Okay, thank you, Minister.
Just a final note before we close, Minister. As tends to happen in legislation, in review of legislation, there were some questions, both among committee members and from others, about the use of certain terms. So, for example, there was a concern about the reference to, certainly in the fifth schedule, talking about individuals whose conduct offends public morality, which has been kept over many decades in legislation, but is so subjective as to make it unclear as to what kind of conduct that is. There were a couple other references that we came across in some of the written submissions. And, you know, there are certain things that certain words mean under law. We know that. However, there are also similarly certain provisions that have existed for a very long time that refer to a time where there was a different culture and a different way of life. And it is important that we make the distinction between those two kinds of things. So, for example, the legislation makes reference to people being accused of disloyalty. The fact that the minister can remove a person's citizenship if they make utterances that suggest, in cases where a person has been granted citizenship, other than because they were born here and so on, that minister can remove a person's citizenship because they make utterances that suggest disloyalty to the country and so on. Some people consider that is a kind of provision that if a person becomes disaffected or disloyal or suggests disloyal behavior, some people consider that as a kind of provision that seeks to create uniformity of thought and ideology. So there's that consideration. And then there's language like conduct that offends public morality that is very difficult to define. Do you have any response to those?
There's certain terms that are what we call terms of art. If we attempt to pigeonhole and put a bracket or a box on everything, we run a greater risk. The list of prohibited persons before was significantly longer, and the wording a lot more oppressive, a lot more restrictive, less open to interpretation. In relation to the conduct which offends public morality, we kept that word in. That was a great issue of discussion. We kept that word in because people tend to accept what is general public morality. What exists for one country might not exist for another. We can only judge in relation to our own particular circumstance. So if behavior is deemed to be such that it be offensive to the vast majority of people, not just persons with particularly sensitive constitutions, then that would tick that box. It was the settling of wording that recognize the individual characteristics of a country and a standard that most people actually understood and can identify with. When we try to condense it into more specific wording, you then run yourself in trouble. You narrowed the consideration for the persons who fit that word in, but you also excluded other categories that should properly be considered but didn't fit into there. So that, I mean, the judge is here, right? The CPC is here. That was the best formulation we could come up with, and that was after we significantly cut down on the prohibited persons to make it a lot more inclusive. I can't get too specific.
I appreciate that. I also appreciate, though, that behavior is either lawful or unlawful. There are laws to cover the unlawful behavior. So if it is lawful...
So let's use the example. I'll give the example that came up. The example was troubling a child. Right? The example that was used was troubling a child. If somebody was charged, pardon? As unlawful. Right. So if somebody was charged with that, and then the child came forward or the parents came forward and said, we don't want to give evidence, the person then doesn't have a conviction. So the unlawful, it was never proved, but if there was sufficient evidence of it, that although there was no conviction, we wanted to retain the right to say, no, we don't want you here. So that was actually one of the examples that were used. There's some other examples. So a lot of this had convicted for this, whatever. Sometimes it's more than a conviction. A conviction is just that something went through a process in a court of law and somebody was found guilty, right? But if there's sufficient evidence there, but you didn't get your day in court for one reason or the other, but we know you did it, or we know you have a propensity there, then why should you escape on the basis that I had a conviction? We know you're troubled little children. We don't want you.
Okay. We don't know. We don't know. I understand your point that we won't reserve the right to make that judgment, which is absolutely fair. We don't know. We also don't say trouble because
I'm speaking in Bayesian part.
Right.
You don't know what I'm talking about.
Right. But I would submit to you that there is language. There's language that does not have to be too detailed, but that can cover that kind of thing. I think I take, and remember I sat where you're sitting on another piece of legislation not too long ago. So I understand that you cannot possibly define every word under the law, right? But I also would encourage us to modernize our legislation. There are certain things that are, and we brought this up in our discussions earlier, and we won't make specific reference to what they are, but there are certain things that cannot be imported because they offend public morality. They're sold in stores all over the world, but they're considered contraband because of these archaic notions of how people should behave. And so I'm just suggesting, and the committee can help suggest language, but I'm suggesting that we may want to take the opportunity to modernize some of what we have just taken for granted over 100 years as given in our culture.
Chair, I hear you loud and clear. You have to look at context. So nobody's going to deny you citizenship in Barbados because you own a rose, right? It may be banned, it may be frowned on by some people, but in the context of what we're talking about, offending public morality for the purpose of immigration status, that would not make the grade, right? Oh, you don't get it? I won't call your name so everybody knows who it is. I didn't get it. All right. But I'm quite willing with the drafters to review suggested wording coming out of this committee that might take us closer to where we want to go. But in the initial draft, that was pretty much acceptable drafting to convey the point when bearing in mind the context of what it is that we're applying that particular provision to. But if the committee, if coming out of this hearing, other wording suggested that we say, well, that hits the spot, then, Madam Chair, as I told you, nothing here is set in stone, and we're trying to end up with the best draft possible.
Thank you. Any other questions, comments, observations, concerns for the minister? Going once, going twice. Minister, thanks very much. We will likely confer with you over the next few days on one or two points clarification. But thank you for coming to present and to explain some things to us to help us in our deliberations.
I thank you for having me. I also want to thank those who actually weighed in. This is a very important committee, and this process is an important one. Some persons have said we should get legislation perfect before we bring it before the House, but there's A, no such thing as perfect legislation, and then B, when legislation doesn't just concern a small sector of society, but has implications on pretty much who we are and what our country is going to look like, then it is critical that we get as wide an input as possible. And this is perhaps the best framework to do it. We did not get to the immigration legislation by accident. We went through a number of iterations of this. There have been consultations over the years in relation to this. We narrowed it to what we thought it should look like, but we bore in mind that there are certain things that we could not pretty much sign off on behalf of the whole of Barbados. And quite frankly, the points that were in contention in drafting are some of the same points that are raised here in this committee. So we are going to go back with the benefit at the end of the day of a report with all those who bothered to tender submissions, appear in person to codify that. And as I said, this is not about trying to shove legislation down anybody's throat. This is about actually coming up with the best way to represent our policy for managed immigration, and that leads to the building of Barbados. So we are open to consider anything that may add value to this legislation. So I thank you for having me. Thank you.
Thank you. With that, I believe that we've come to the end of today's meeting and that we can adjourn. Thank you, everyone. Sorry, we skipped any other business. I feel as if we've covered a lot of business. Any other business? If not, we are adjourned. Motion to adjourn. We are proposing that we adjourn to Tuesday, the 11th of November, that's the month, at 10 a.m. Would anyone like to move?
So move, secondly.
I move that you second.
Moved by Senator Springer, seconded by Mr. Phillip. And with that, we are adjourned. Thank you very much, colleagues.